Original side mentioning.
My lord, may I have your lordship's leave to mention this matter, or I need leave to file this appeal without the certified copy of
When
law?
was the order passed?
Order was passed on 20th May, my lord. I have applied for a certified copy on 22nd of May.
Granted, granted.
Very grateful, your lordship.
My lord, one.
Can't hear you, sir. Use the microphone.
One review petition has been filed before your lordship and assigned matter. That matter I want to mention it before your lordship because it is pending before since 2002, and that but the review application was filed, and that after 851 days delays, and that matter was appeared before your lordship.
Review was filed in 2002.
No, sir. Review was with 2020-23.
Whose order?
Who does order passed by the Honorable Justice Sanjeev Banerjee and
আমাদের কি করে determination থাকবে?
And question, it is assignment.
ও অ্যাসাইন করছে। এ আবার কোথায় অ্যাসাইন হলো? দেখো। হ্যাঁ? সন্তোষ সাহেব, দেখো যা করার করো।
Your lordship's kind leave to mention a matter which was to be listed sometime in Milord April. Parties were attempting to work it out with Milord this is for execution of a conveyance. Through Milord Mr. Deepnarayan Mitra, Milord, who is the special officer to draft and Milord prepare the conveyance. Ultimately, it couldn't be. Milord, if your lordships permit, Milord, the matter to be listed, Milord.
My lord, this is an appeal under Section 37 Arbitration Act. It has been filed. It is pending for last 3 years. So
give it.
Any appellate side mentioning?
No, Original side non-commercial new application item number 1.
Madam, for the appellant, respondent defendant, my lord. My lord, this is my application GA2 for substitution for recording the death of 2 of the respondent, my lord, who died earlier, my lord, but the knowledge of death was come to the petitioner, my lord, during the pendency of the appeal by virtue of an order dated 21st of November 2024, wherein, my lord, the substitution before the trial court was allowed, my lord.
Why 2 applications? Which is a substitution application?
My lord, GA2 is a substitution application, my lord. GA1 is the application for stay, my lord. My lord, the issue was raised before you, my lord, on 1st of May, when the matter was taken up, my lord. My lord has granted liberty to take necessary steps, my lord. In pursuance thereof, we have inserted this application, my lord.
My lord, I'll not oppose this application except for the grounds that have been made are not really sustainable for the delay in filing the substitution application. By their own admission, the order for the substitution.
Madam, if you're not opposing, don't oppose.
My lord, I could just indicate the
application to thou.
My lord, the proposed amendment is in page 17, my lord, Annex D, marking the red wing, my lord. My respondent number 3, my lord, Anul Vinod Kumar Jaiswal, and respondent number 7, my lord, Madhuri Jaiswal has, my lord, died. My lord, the details of the legalese is described in paragraph 11 of the application, my lord, that is in page 7, my lord. My lord, page 7 and 8, my lord.
Issue. We will record your submission that the grounds furnished for the delay are not tenable.
But because by their own admission, the order was allowed on the 21st of November.
But in the interest of justice, we are allowed.
That's all.
GA2. Huh? This is an application for recording the deaths of the respondent number 3 and the respondent number 7 in this appeal, who passed away during the pendency of this. No, passed away before the appeal. Deaths, who passed away, stop. When did they die?
My lord, that is mentioned.
Stop. It appears that the respondent number 3 passed away on November 29, 2015, and the respondent number 7 passed away sometime in December 2012. Stop. The appellants / petitioners say that they were not aware of the deaths of the said respondents. Stop. They came to know of the same only when substitution took place before the learned trial court. Trial court meaning what? This court?
No, my lord, this court, my lord.
Learned first court. Learned first court. Stop. Paragraph. Learned advocate for the
Plaintiff respondent. I'm for the plaintiff.
all the respondents.
I'm for the plaintiff. Plaintiff respondent.
Plaintiff is which respondent? How many plaintiffs are there?
Respondent number 1.
For the respondent number 1 / plaintiff,
Lordship 1 and 2. Respondent number 1.
plaintiffs / respondent numbers, respondent numbers 1 and 2 / plaintiffs says that the petitioners were at all material times aware of the deaths of the respondent numbers 3 and 7. Stop. The ground that the explanation sought to be advanced for the delay is not acceptable. Stop. Paragraph, be that as it may, comma, for the ends of justice, we allow this application. Stop. Let the names of the respondent numbers 3 and 7 stand deleted from the cause title of the appeal papers, and the names of their respective legal heirs be substituted as indicated in a copy of the cause title of the appeal papers annexed to this petition and marked as D, capital D within inverted comma. Stop. The department shall carry out the necessary amendment within a fortnight from date. Stop. After the amendment is carried out, comma, the stay application may be reaffirmed if necessary. Stop. Copy of the amended cause title be served on the advocate on record for the respondent numbers 1 and 2 / plaintiffs. That is all. Paragraph, let the appeal be listed 3 weeks hence. GA2 disposed of.
Item number 2.
Wait, please, Your Lordship. Lord, Your Lordship has directed a notice to be served on the respondent. I have served, my lord. They have been served. Lord, this is an appeal from a judgment and decree.
1 second, Mr. Kaur.
I'm sorry. I'm sorry.
Yes, Mr. Kaur.
Lord, this is an appeal from my suit for
Are all the papers before us? Because practically we will be hearing out the appeal.
Yes, my lord. My lord, I was praying this. Your lordship will allow me to, the evidence is not there, my lord. So some paper book is necessary.
Informal paper book
Informal paper book
within
a period of
of
10 days, my lord.
10 days.
Huh?
Pursuant to our direction dated, pursuant to our order dated, our Bolona, pursuant to the order dated May 22, 2025, fresh service has been effected on the respondents as would appear from the affidavit of service filed in court today. Stop. However, nobody represents the respondents. Paragraph. This appeal is directed against a judgment and decree dated April 3, 2025, whereby the appellant's application for grant of letters of administration in respect of what she claims to be the last will and testament of late Girindro Kishore Pal. What's title আছে দেখে নিও বানানটা পাল চৌধুরী stop stop the appeal has to be heard out. Stop. Paragraph. Let requisite number of informal paper books be prepared by the appellant, incorporating therein all papers that were available before the learned single judge. Stop. All formalities are dispensed with. Stop. Let notice be issued by the department to the respondents. Stop. Notice of appeal করে দাও. Notice of appeal be issued. So, paragraph. Let the appeal be listed 2 weeks hence. Oh, আচ্ছা ওইটা paper books within 10 days করে দাও. Requisite number of informal paper books be filed. ওখানে add করে দাও within
15 days.
Within 15 days. তারপরে incorporating therein. Then appeal be listed after 3 weeks. After
As a short
3
appeal,
weeks.
my lord.
There's no such heading. Let it come.
My lord, under the rules, my lord, there is a provision.
After 3 weeks. Stop. The stay application stands disposed of. Stop. However, a copy of the stay application be included in the paper book.
Very well. Very well.
So, GA টাকে dispose of করে দিও.
I'm grateful to your lordship.
Item number 3.
No opposing, my lord.
I'm for the respondent praying if the matter can be taken up tomorrow. My junior is not there, so one day only.
We have no problem.
One day. And I think their urgency is because there's a
AGM.
and the nomination of the nomination form is to be filed by 13th. So I think one day, my lord, I think tomorrow it can be taken up.
The difficulty is, my lord, I'll tell your lordship in a minute the background. My lord, without a show cause notice.
We are not hearing it today. Why give us the background? Either you agree to the request or you don't.
I find it not extremely difficult to disagree. But my lord, let's my lord, try and look at
If you agree, then Mr. Chaudhary, why apprise us of the facts today? We'll forget by tomorrow.
No, I am not trying to prejudice your lordship or anything, my lord. I was only, I suggest a very fair, workable arrangement. Fair, workable arrangement. My lord, matter relates to, my lord,
Your client has been suspended.
My client has been suspended in violation of natural justice. And, my lord, he's been sent for expulsion, which is, my lord, fait accompli. On no, my lord, basis. Large, my lord, case of prejudice also made out. Now, this year's election, surprisingly, is held, my lord, now. Normally, it's held in September or beyond. I have a list of, my lord, previous elections. Last date for nomination, my lord, is tomorrow,
Day after tomorrow.
day after tomorrow. Lord, it's not, my lord, that I'll get an interim order saying I can, my lord, participate when I've not been suspended and I'm being sent for expulsion. I'm only humbly praying, my lord, that if your lordship, I'm not praying for an order also. If your lordship, my lord, keeps this in mind and it's understood by all of, my lord, us counsel, my lord, that in the event I succeed before your lordship and my suspension, my lord, is revoked, I'll be allowed to participate in the election. Though, my lord, the last date would have gone away by then. My lord, I don't, my lord, it could take 7 days, 8 days, or maybe 2 weeks. But even then, there'll be
No,
time.
last date for nomination is day after tomorrow.
Election
When
is 5th of July.
5th of
5th of
July.
July.
So I'll have the time.
Your lordship can undo it. If
Well,
you
let him first open up the case, my lord. We'll see that. Because, my lord, there is a question as to whether this application will be maintainable or not, my lord. So kindly keeps it tomorrow.
Mr. Chaudhary, if you succeed,
Yes.
we can always permit you to participate.
Yes, that's all that, my lord. Because even if I succeed, the problem would be that the last date for filing my nomination would have gone by then.
We will permit you.
That's all, my lord, that I'm asking.
Saying that since we have found
Yes.
that the suspension is illegal and we have set aside the suspension, and because of the suspension you could not file nomination, therefore we permit you to
Yes,
file.
my lord, that is all. That is all. I just wanted, my lord, that little comfort that I could, my lord, if I succeed.
He doesn't want to enter into any understanding.
No,
but
I understand.
No understanding, my lord.
I
Kindly, my lord.
understand. I also don't want
Ray,
to.
my senior from London, he's also agreeing to it. Man.
Oh, is he from London?
From London, right?
My
I'm
lord,
so sorry, my lord. But at least I had the option of
6:15. 6:15 he has woken up in the morning.
my lord.
Greed for money.
which is why, my lord, there's no light around him.
On him.
On him or, my lord, anywhere.
Very well. Then
That we'll come back tomorrow as
Come
my
back
learned
tomorrow.
friend wants. We have no difficulty.
not today.
Tomorrow, my lord, I believe is a commercial day, my lord. We'll come back day after, my lord. Yes. Whenever it's called.
You see, tomorrow is what day?
My lord, isn't, my lord,
Appellate side to chatte mamla.
oh, very well.
So after that we take up
Yes, my lord, we'll be.
commercial. Anyway, let us see.
My lord.
We'll be here, man.
Bas, ठीक है. I am not there tomorrow. Mr. Banerjee, my lord, is leading me. But he'll be.
Tomorrow it may not be taken up. Let us see.
Item number 4 and 5.
ये
I would it.
But I go back to the special referee's report. Lordship, I was also trying to figure out, because my lord, the special referee's report, in a sense, my lord, whatever I say, I am also conscious how that figure of 60 was derived at. There is no indication in the report. So, my lord, those 5 reasonings, the advantages and disadvantages were discussed, but it doesn't. It appears to me, and I am saying it out of conjecture because there is no other material on record, that my lord, the special referee has perhaps made a back calculation, because 60 rupees he has taken for 2018, and that is why, my lord, I was also troubled. I pointed out to your lordship, 10% annual increment is normally not done. It is usually at the gap of 3 years. Whatever 10 or 15, that's a different issue, but usually done at a gap of 3 years. But if that is done, my lord, 2018, if it is 60 rupees, 2019 it will become 66, and my lord, 2020 it will be near about 72, which is, my lord, in line with the Sampark agreement. So, my lord, this is what perhaps, my lord, could have been in the mind of the special referee. I can't say that this was the only consideration, because there is nothing in black and white, but this is perhaps the consideration. But, my lord, kindly see, my lord, one fact at page 370. Even the Sampark agreement had an increment, lordship will find at clause 3, right at the top. Component B of monthly rent shall be enhanced after expiry of every 5 years at the rate of 12.50% over and above the last paid component. So, well, this is the part which the special referee overlooked. Assuming, well, he has taken this into consideration, because the other leases are all after 3 years. I'll show those also. All increment, but Sampark agreement is after 5 years, increment is 12.5%. Now, my lord, I am, by way of submission, my lord, I have to persuade your lordships, my lord, why I am saying that on 2018, the rate has to be less than 60. I have to cross that hurdle. Or, if this is taken to be the best evidence which can be on record, because, well, it's now well settled that either sale value or market value of the self-same premises is the best evidence. It is well settled. I'll cite one judgment also. Now, if this is the best evidence, then, my lord, I have to satisfy your lordships why in my other application, 2 appeals are there, why I am saying it is less than 60. And I just tried to, my lord, give a reason what perhaps could have been in the special officer's mind. And I have tried to show that why it is wrong. Now, my lord, this document, this Sampark agreement, my lord, is of the ground floor. Lordship will find that, my lord, it's there in the recital, page 380 also. Lordship will find ground floor plan at premises so and so. It's in the ground floor. It has the road frontage. It's a showroom frontage. It's in the ground floor. Now, what is the law in terms of principles of valuation? That for the same premises, if you have a valuation of the ground floor, can the first floor be equal? The answer is no. The first floor will be slightly less. The second floor will be lesser than that. Especially lift facilities not being there. And this has been, now, my lord, and, my lord, this Sampark is not an old tenant, my lord, it's a fresh induction. So we have this. Now, my lord, one judgment I want to cite. This is a division bench judgment.
Isn't there a judgment of this court in Dalhousie Properties Limited? Have you just tried to see? On mean profit.
Dalhousie property, I mean, this I am showing, my lord, this is on the principle that if it's a 3-storied building and the total building is valued at 100, the ground floor will be 40, the first floor will be 35, the second floor will be 25. This is Justice Sikri presiding over the division bench, a Delhi High Court judgment. Because, my lord, I have to show in terms of law, on principles of law. Otherwise, my lord, my learned friends can say that whatever I am submitting again, it is on, you are just indicating the advantages and disadvantages without giving a reason or a rationale as to why you are saying figure X. Because my criticism is, why not 55? Why not 56? Why 60? Why 65? That is what I am criticizing. So on one hand, while I am criticizing that, I'll have to make good that why I am saying that it has to be less than 60. So I am, my lord, trying to establish that. Now, my lord, straight away, kindly come to, it's a small paragraph, I'll just rely. My lord, this is a case, my lord, pertaining to, my lord, arising out of partition of properties where an immovable property was being considered and one brother got one floor, other brother got the other floor. So the question was whether valuation of the two floors can be the same. It is in this context. But my lord, and my lord, this is, my lord, the closest that I have been, and one of my favorite judgments, my lord, so far as mean profit is concerned, because this is only one of the few where, my lord, lordship will find a judicial recognition of certain principles of valuation. Kindly come to paragraph 15. The rest of paragraph 15 is not relevant. My lord, I just rely on, my lord, this is in the context of, my lord, a probate where, my lord, there is a valuation and all these stuff are involved. But kindly see the last 4 lines. Last 6 lines. Thus, higher value of ground floor is compensated by giving those two sons the second floor, which was of least value. Then, my lord, this is very important. Judicial notice can be taken of the fact that normally ground floor of property is treated to be of 40% value, first floor 35%, and second floor 25% in value. Thus, the two sons who are given ground floor and second floor in equal portion will get about 32% each, and the person getting the first floor gets 35% by dividing. Well, I am not, well, kindly, I am only relying on this line. Judicial notice can be taken of the fact normally this. So, my lord, if the whole building is valued at 100, ground floor will be valued 40, first floor 35, and the second floor 25. Now, my lord, if we have the best possible evidence of 72, which is of ground floor, so 40 represents 72, so 35 will be 63. We work out that ratio. Unitary method, we work out the ratio. That comes to, my lord, 63 rupees. That is 72 divided by 40 into 35. Applying the ratio of this division bench Delhi judgment. Lord, have I been able to make myself clear?
Yes, but you said it will be less than 60.
I'm coming to that. I'm coming. Well, all this valuation is of December 2020. Well, the Sampark deed, because, my lord, I have to take that date in question. The Sampark deed, lordship will find at 367 is of 22nd December 2020.
So applying this formula, it will be about 63, you said.
63 rupees as on December 2020.
Yes.
Now, there are two possibilities. If lordship takes the other leases which are there, which has a 15% enhancement every 3 years, then, my lord, for 2018 or from December 2017, lord, the lease rent or the market rate would have been 15% less. 63, 15% less, 57, 55. একবার করো তো, এখনো করো। Lord, From 63 rupees, if 15% less we arrive at.
Why 15%?
Well, on the basis of the lease documents, well, every rental increment is 3 years. So we are back calculating. So if we back calculate, well, 3 years prior thereto, it's a fresh agreement. On 2020, we are having a fresh agreement. So 2020 from December 2017, on December 2017, 15% discount, if we say so, it comes to 53 rupees. 53 rupees 50 paisa, 15%. And if Lordship takes, well, there is another way of looking at it, considering it is a 12.5%, Malad, at page 370, Lordship finds that. That is for 5 years. So, Malad, you go back 5 years, Malad, from 2015, December 2015. If Lordship takes a 5-year period, Malad, it will be 12.50% discount. Malad, these are the parameters, Malad, whichever it is for your Lordships to decide. But this is the parameter. So, whichever way my lords look at it, 12.5. If 12.5 is taken, my lord, it is 55 rupees. And 15% for 3 years, if that slab is taken, it is 53 rupees 50 paisa. That is why, my lord, I had submitted that whichever way Lordships look at it, it has to be less than 60 and it is coming around 55 rupees.
Yes.
And my lord, now I show your Lordship why this was not forthcoming from the part of the plaintiff and how it surfaced, my lord, in course of evidence. Kindly take volume 1, page 81. But I rely on question 69 to questions 74. In fact, I placed till 81 because there was no default and that was what was the market rate and the best possible evidence is that also one case I'll cite.
Whose deposition is this?
This is the deposition of PW1, plaintiff's witness 1, Nitin Jain. The valuer was the second witness. Question 69. Apart from these 3 tenants or occupants, these tenants who have been referred to earlier, they are the old tenants. So I am not troubling your Lordship with that. Who else is in occupation of portions of the building? There are some subtenants in the premises and one new tenant, Sampark Advertisement Private Limited, in short Sampark, under whom the subtenants are claiming right under Anuradha Devi. When did you induct Sampark? In the year 2021, month I can tell you on the next date. Subsequently, he produced the document. Actually, it was in December 2020. He has said 2021. In which floor of the building is Sampark in occupation? On the ground floor.
This is cross or what?
This is cross-examination. Cross-examination by Mr. Dotto. In which floor of the building is Sampark in occupation? On the ground floor. Is it on the rear side of the building or on the front side of the building? Front side of the building. What is the area of occupation? They were given spaces in 2 parts in total. It is 5,400 square feet. But we have documentary evidence of only 2,100 square feet. So, who on behalf of plaintiff signed the agreement? I have signed the agreement. Will the terms of the agreement appear from the plaintiff and Sampark from such agreement? Yes, they will appear. I call upon you to produce a copy of the agreement that the plaintiff had with Sampark on the next sitting. I will do. Then, my lord, kindly come to question 80. What is the monthly rent that the plaintiff receives from Sampark? I'll have to check and come back to you on this because rental comprise a very high based high interest and a monthly payout of which both form part of rental consideration of the premises. Default and no default. And my lordship will find at the next page, page 83, question 82 answer. He produces the document, and that is how, my lord, that tenancy agreement comes in the records of this proceeding. Witness produces tenancy agreement dated 12 December, entered into between swears. And my lord, this is perhaps the special referee, while arriving at a figure of 60, 72 rupees was, my lord, that was the domain, and my lord, 60 was taken as a base figure because, my lord, perhaps there was some amount of back calculation. Otherwise, it cannot be. But if 72 is taken as a figure in 2020, my lord, I have relied on the Delhi High Court Division Bench. There are, my lord, 3 distinguishing features of the Sampark property. Number 1, it's having a frontage on the road, whatever road is there, Juice Gully or whatever. Number 2, it's on the ground floor. And number 3, it's on the front portion. Unlike the suit property, which is in the first floor, rear portion, and doesn't have any frontage on the. And as a thumb rule, a broad principle, judicial notice whereof has been taken. I have cited the Delhi Division Bench that if a construction, and that was also a 2-storied building, if it is valued at 100, broadly it can be said 40, 35, 25. And there I was trying to figure out, my lord, this I tried out, but I couldn't, that why judicial notice has been taken there, what are the other cases, but my lord, I could not lay my hands on. But my lord, this is a ballpark, my lord, this is a judicial notice, at least one division bench is there of one of our high courts in our country. So this is the parameter. So on this basis, my lord, my respectful submission is, and because the Sampark document is there, and my lord, one more judgment I cite, this is, lordships are aware of this judgment, my lord, this is just for formality, that the best evidence is the evidence which is of the self-same property. My lord, for that, my lord, I cite AIR's, 1975 2 SCC 730. This is, of course, my lord, in the case of valuation pertaining to the Land Acquisition Act. But my lord, principles of valuation, my lord, the broader principles regarding best evidence, my lord, it's of universal application. My lord, paragraph 5. Because one of the reason why I am citing this is it is convenient to get, instead of Parks on valuation, and I give my book for photocopying, this has quoted from Parks on valuation. Therefore, my lord, I am relying. Paragraph 5, my lord. It is true that compensation for compulsory acquisition as governed by section 23, well, this is of course of the Land Acquisition Act, gives higher priority to market value of the land at the date of publication of the notification under section 4, subsection 1. But what is market value? It is a commonplace of this branch of jurisprudence that the main criterion is what a willing purchaser would pay to a willing vendor. Ordinarily, a party will be entitled to get the amount that he actually and willingly paid for a particular property, provided the transaction be bona fide and entered into with due regard to the prevalent market conditions and is proximate in time to the relevant date under section 23. We may even say that the best evidence of the value of the property is the sale of the very property to which the claimant is a party. My lord, I am just extrapolating this to, my lord, rental conditions. The best evidence of market rental value is the rental available in that period of the self-same premises. between a willing purchaser and, my lord, the plaintiff himself is involved in this.
Isn't that common sense?
This is, I am only relying on it because Lordship will see principles of Park on valuation, 4th edition, and that has been relied upon. If the sale is of recent date, then so and so there has been no appreciable rise or fall, and that nothing has been done on land during the short interval to raise its value. Nothing could have been done. Premises already more than 100 years old. All those factual aspects are there. It is only for this. So I don't have to, my lord, give Parks on valuation. This is a easier thing.
How much does it cost now, Parks?
My lord, my edition is currently, I believe this is the 4th edition. This is, my lord, I am having the 6th edition. I don't think it was 850 rupees. I don't know whether there has been a further addition to that. This was in 2015.
The original Parks? This is an Indian edition.
The license has been taken from the 5th edition by Eastern Law Book.
I see.
Eastern Law House, I'm sorry. This is the Eastern Law House publication.
You know, Russell and Arbitration, they cost something like 20,000 odd.
Now, my lord, some of the classics, they have entered into a license agreement with couple of Indian publishers.
I see.
And Indian editions are available, which is
more affordable.
Just like our, it is now Russell, I believe, is now 7,000 or 8,000.
I see.
That's the Indian edition. And my lord, so far as Parks is concerned, subject to correction, I think 6th edition was the last edition. I don't think there has been a further, or maybe one more edition might have come in. But I have, my lord, it is not desirable to dispose of old editions for these flag marks because it is, again, you have to do the same exercise, which is tedious. So, my lord, this is the part so far as, my lord, that is why, my lord, if I may sum up, my lord, the learned judge, my lord, I was also trying to think that what could have been, my lord, a logic which could have been followed by the learned judge. He may have worked out 90 rupees from 106 rupees. That can be one of the logic. It's not exactly fitting into any percentage. It can't be 10% or 15%, but it can be one of the logic. Just as I tried to, my lord, work out, and these are all conjectures, my lord. I am putting it by way of my submission. But, my lord, that is completely, my lord, wrong for the reason that this 90 rupees militates against the available evidence on record, which falls in the category of the best possible evidence because it is of the self-same premises, which shows 72 rupees in 2020. And if that is taken, so it can't be 90 rupees that militates against that. And if this is taken to be the best possible evidence, then also considering the fact that it is of the ground floor, kindly apply the ratio of the division bench of the Delhi High Court, that ground floor 40%, first floor 35, second floor 25. On that ratio, if it is worked out, then in December 2020, as on date of the Sampark agreement, this would work out to 63 rupees. That is, my lord, 72 by 40 into 35. It works out to 63 rupees on the same ratio. And if that is the, my lord, rate when this agreement was entered into, if lordship goes back, my lord, two options are available. Either you adopt the 15% formula for every 3 years. So from December 2017, less at 15% discount of this, my lord, 63 rupees, it will work out to 53 rupees 50 paisa. Or the other alternative is the Sampark agreement as on 2020 says there will be an increase of 12.5% every 5 years. So you work out, you go back to 5 years around, it will work out to 55 rupees. 55 rupees. And even the learned judge, my lord, has overruled that part of the finding of the special referee of 10% increase every year. That, in my respectful submission, doesn't fit into until and unless there is some form of an express agreement, my lord, it will be a peculiar agreement or a unique feature. My lord, it is not a general principle of valuation. Lordship will not find, neither, my lord, from any evidence it will appear that, my lord, there is an increment every year. Of course, my lord, there can be, my lord, there is no embargo in that, but all the documents which have been relied upon, my lord, all the increments are of 15% every 3 years. The lease documents are 15% every 3 years, and Sampark is for that. My lord, there may be one agreement which has been relied upon of Bata. Bata, because of that, there is an annual increment. Because of the locational feature of that fact, because it's right on Chaurangi Road, and my lord, it is there. That is there. But even if Sampark is taken, my lord, it is 55 rupees. Because this is the best possible evidence. And for the last 5 years. That is from, my lord, 2015. 2015 December to 2020, on the basis of this, my lord, it has to be 55 rupees. And if you take 15% less, then it will go down to 53 rupees 50. Those are my decisions. Oh, one more aspect, 5 more minutes. This is regarding the evidentiary value of a certified copy. Lord, evidentiary value of a certified copy so as to be an evidence of the truth of the contents of the certified copy. Vis-a-vis, my lord, establishing market rate, because, my lord, a certified copy per se may not prove that it is an arm's length transaction between the parties. We are covered by, my lord, this was cited by my learned junior before the learned single judge, but this aspect has not been gone into. Just for completeness, I am also, my lord, citing this. My lord, prior to that, kindly come to page 145, volume 1. देखिए. Girish Gupta judgment. एक बार बाड़ी की হবে তোমার তো কাজ হয়ে গেল বুঝে At page 145, if I may place a few questions from question 104. 103. Therefore, I take it that your evidence is now that Nitin Jain, the director of the plaintiff, provided you with the 2 deeds referred to in page 8 of Exhibit D. Is that so? Yes. Are you a witness or an executant in either of the 2 deeds exhibited in the proceedings and marked Exhibit K and Exhibit L? No. Do I take it that it is not possible for you to comment about the truth of the contents of the 2 deeds being Exhibit K and L? Yes, that is not possible by a valuer. Apart from the purported locational advantages that you have referred to in Exhibit D, did you refer to the facilities or amenities that are provided to any occupier or tenant in the building standing on the said property? Not in detail. Shown part 1 of Exhibit D, according to you, where is the reference of any facility or amenities that is available at the subject property? Witness refers to page 4. Do I take it apart from clause 24, there is no other clause referring to any facilities or amenities? There are no other clauses. Now, in this aspect, kindly consider the division bench judgment dated 13 July 2015. But I am not sure whether it is reported or not, but since I have given a copy to my learned friend also. This is in APD 2 of 2014. Well, it kindly comes to page 3 of this judgment. Well, in page 3, in the middle, Lordship will find there is a reference to the cross-examination. Well, this was also determination of mean profit involving certified copies. Questions have been referred to. I quickly refer to the questions. Question 143 onwards is referred to. The registered indenture dated 12 January was between Subir Udyog and ICICI Bank. Am I correct? Yes. Wherefrom did the plaintiff get the certified copy of the indenture? From any advocate. The plaintiffs have nothing to do with the registered indenture dated 12 January? Yes. So I take it that the plaintiffs were not in a position to tell my lord whether the content of this document registered are correct or not. This is the certified copy, so it is correct. Do you know personally whether the content of this document are correct or not? I presume that the certified copy, it has to be correct. I put it to you that a certified copy of a registered indenture does not prove the truth of the contents of the document. I disagree. My lord, this is one of the few cases, my lord. Now, my lord, 80% difference between, my lord, a truth of a document and truth of contents of document. These distinctions are, my lord, part of history now. But, my lord, just for completion, since this was referred to by my learned junior there, I am citing this document. Now kindly see, after quoting this, my lord, how the division bench frowns upon, my lord, mechanical reference to certified copy and therefore presumption that the truth of the content is also correct. Because this certified copy, lordship knows that secondary evidence, one of the sine qua non is that either the primary document is destroyed or I have not been able to, and this has not even been collected by the valuer personnel. It has been handed over by somebody else. On the basis of the aforesaid evidence, it is not possible to arrive at a finding that the rate of 2,44,000 was the market rate prevalent on or with effect from September 2008. Nor on the basis of the aforesaid evidence, it is possible to decipher that the transaction was entered into in the year 2004 at the prevalent market rate and not an inflated rate. Nor is it possible to decipher whether the transaction appearing from Exhibit F was actually acted upon or abandoned. Solely on the basis of Exhibit F, it is not possible to hold that the defendants could have with ordinary diligence received mean profit at a sum of so and so from the demised premises. In the absence of any definitive evidence, the direction to pay mean profit at the rate of 2,54,000 is not sustainable and is therefore set aside. This is, of course, a subsidiary point. I have already made my submissions vis-a-vis this. And Millard, one more question just for completion I show to your lordships. At page 142, question 77. This is, my lord, apropos the valuer. In fact, the valuer in his suggestion, my lord, he was forced to agree that there was error in substantial portion of the report, but entire report can't be wrong. Question 77, lordship will see. I am suggesting to you that your report is unintelligible. There can be error, but it cannot be that the entire report is wrong. And even, my lord, notwithstanding this admission, the valuer had, my lord, one more page. Page 66. I think I had shown to your lordships, but my lord, just for confirmation. Page 66, volume 1. This has been very craftily done. Well, at page 66, lordship will find. Well, kindly see declaration at the bottom. I hereby declare that the information furnished in part 1 is true and correct to the best of my knowledge and belief. And the valuation is part 2. So the valuer doesn't take responsibility of his own valuation. And my lord, on this aspect, questions were also asked to the valuer. Page 136, my lordship will find that. 3 questions I just showed to your lordship. It will, my lord, further buttress the point that I am trying to put across. But question 35 onwards, my lord, when I had shown the valuation report, lordship would have noticed, my lord, he had given a list of tenants and all that who are there. So, my lord, kindly, my lord, in fact, my lord, if lordship comes from page 135, question 31 onwards, that's very important. All content of the valuation report are information feeded by the plaintiff. Page 135, question 31. Shown page 8 of the report. What are the particulars mentioned in the report? Details of tenants as provided by client. Does page 8 of your report anywhere indicate that the particulars indicated in the table were provided by your client? At page number 8, it is not indicated, but in the first page of the report, it has been mentioned information is received from the client. Now, if that had been so, then Sampark would have been in the knowledge of the valuer. Now, will it kindly see question 33. Therefore, I take it to be your evidence that part of your report is based on information provided by your client and not your own assessment. Yes, that is so. The name of the tenant is their information. Did you as surveyor and valuer accept authenticity and veracity of the particulars indicated at page 8? Because it has been provided, I accept such authenticity. Lord, all those practice of valuers going there, making investigation, collecting documents, and then giving report, my lord, is history. And my lord, one more question, question 36. What about the names that appear in this chart? So far as the rest of the names are concerned, since I have not seen it personally, I cannot confirm. Do you find the name Government of West Bengal, Office of Deputy Director Fisheries is not appearing at page number 8, which according to you was furnished by the client? Yes, that is so. That can be a portion occupied by any subtenant. Is this guesswork or assumption or assessment or certain about you are certain about your previous answer? When the name of Government of West Bengal not appearing at page 8, then it is evident that Government of West Bengal is a subtenant of any of the tenant. Is this information regarding subtenancy provided by your client? No. So he's just making conjecture. Then question 40. On what basis then have you deposed about such alleged subtenancy? I do not know on what basis I have deposed about such alleged subtenancy. Are the locations mentioned personally verified? Most of the portions have been verified. A few may have been missed out. Please identify the portions which you have verified from page number 8. Sir, I have forgotten which I have verified, therefore I cannot give the answer. That is why, my lord, in my opening argument yesterday or day before yesterday, I had said that I can also show that the valuer perhaps did not visit the premises at all. He has simply taken the 2 deeds provided by the plaintiff, taken the data, collated it, prepared a report and come to give evidence. And he has been totally exposed in cross. So, my lord, this I am showing only to show that even the 2 deeds, well, it's certified copy, we mechanically say, all right, certified copy of the Bata showroom, we are all aware. We somehow presume that it is correct and it is an arm's length transaction, whatever. It may be because of the heritage thing or because of the peculiar, it's one of the most popular showrooms of Bata. Bata would go anywhere beyond the market conditions to ensure that they stick to that showroom under rates which may be much higher than the market rate. So there can be peculiar circumstances. That is why, my lord, the division and my lord, simpliciter per se certified copy does not prove the truth of the contents. And on that basis, you can't. You had to examine then perhaps somebody from Oberoi or somebody from Bata. That is the classical, my lord, that's the classical way of proving the truth of content. But, my lord, this aspect, my lord, in present suits has been given a total go by, but be that as it may, my lord, I have independently shown that from their own evidence, if considered to be the best possible evidence, 72 rupees as on 2020, which becomes 63 rupees as on 2020 December because of the ratio of Delhi High Court division bench. And if it is 63 rupees on December 2020, well, whatever 15% or 12.5%, it will work out to either 53 rupees 50 paisa or 55 rupees as on March 2018. Well, those are my results.
We come back any day next week,
Come back.
barring 17th, any other day. 17th, Mr. Thakkar is not there.
16th.
নতুন
তুমি বললে যে
16th, Monday. Mr. Chaudhary, learned senior counsel representing the appellant, concludes his opening submission. Paragraph on the request made on behalf of, it is 9 and 10, na? A respondent, let this matter be listed again on 16, June 16, 2025, when learned advocate for the respondent will advance his argument.
both matters, 9 and 10.
Listed ওই হ্যাঁ listed যেটা বলেছি, retaining its position. কি বলছে ও? হ্যাঁ হ্যাঁ, তো একসঙ্গে হচ্ছে তো অর্ডার।
Great, deeply obliged.
এটাও পাঠিয়ে দিও, লিখে ফেলবো।
Item number 11.
I am for the appellant, my lord. Last occasion, my lord, my learned friend has refused to accept the paper book, my lord. So, my lord, your lordship directed me, my lord, to serve the paper book directly to all the respondent. I served all the respondent. Thereafter, my learned friend advocate on record, my lord, wrote a letter to me, my lord. He has returned the paper book also, my lord. That
Why?
Today he is also.
I have filed the Vakalatnama yesterday.
Yes,
The erstwhile advocate, probably the erstwhile advocate returned paper book.
Yes, yes.
So take now. Give her.
We have already served. We have already served when the erstwhile advocate. Yeah, when the erstwhile advocate on returned the paper book, we have given the paper, served the paper books upon both the defendants by post. This is the paper book. We have served. It's with her.
So are you ready in the matter?
Let them start. I'm taking.
What? Then where is he? We are not going to adjourn the matter after that. Yes. Thou.
Two issues falls for consideration in this appeal. Whether the learned single judge was justified in granting an unconditional leave to defend to the defendants in the present suit or not.
Eviction.
Eviction suit.
A.
13A. Granted an unconditional leave to defend to the defendants. Suit for eviction.
Let us see the impugned order. You need.
That's appearing at the
Ashini.
Yes. Paper books. Shall I place the impugned order?
Let us read it. You take your seat.
Great.
Mr. Dev, this is an appealable order. That's all right, no? Yes.
Now, the two issues which falls for consideration. The first is whether the learned single judge was justified in not granting me a summary judgment and decree for eviction or not. And if the learned single judge is of the opinion that yes, there is a triable issue, whether the conditional or an unconditional leave should have been granted or not. That's a two issue. If the answer of the first issue is in the affirmative, yes, they were entitled, justified in not granting me a leave to defend, then a condition should have been imposed or not. That's the two things. Now kindly come to the impugn order. The Lordship has read the impugn order. The impugn order sets the facts of the plaint, their objection, and the last operative portion.
Original side rules আছে তোমাদের? Regional side appeal court কৌশিক এটা। ওনাকে দাও একটা। When did the defendants enter appearance in the suit?
My lord is on the outer limit of
Yes,
10 days.
10 days.
I have taken this point, but I have
They have given
You're
up.
not pressing that point.
10 days. There is some doubt, but before the trial court, I did not take this.
Right.
Why so? Lordship is saying after written
Yes,
statement.
yes.
I did not argue so.
All right, then.
The Lordship will kindly come to the plaint.
Mr. Dotto,
Yes,
we have read the order. According to us, the defense or the tribal issue is not a moonshine one. Today, after the period of 25 years expired, rightly or wrongly, they transferred an amount of a sum of money,
7,000.
saying that it is rent for August to December 2020. You did not return that money. What you say is that you were entitled to and you did adjust the sum against enhancement of rent in terms of the formula inbuilt in the lease deed. Right? Prior thereto, you never demanded this enhanced rent. This is good enough for us to hold. There is a triable issue. Please do not.
Kindly see three things, only three things.
Yes.
My lord, kindly see three things. First, I will show the clause of the lease deed which entitles me or cast an obligation upon them to pay an enhanced rent. 10% after a periodical enhancement. Secondly, I will show two documents only, pages 45A and page 128. Because words of mouth will not improve my case. Kindly see those two documents, page 45A of the paper book and page 123. 45A, when they raised this point, I, by a letter, gave them a detailed reply. It's not a case where when the matter is before the court, I come up and say. It's before the pre-suit, I say this. 45A. I am in receipt of the letter dated 14th October 2020 and noted the contents thereof. At the very outset.
One more thing, sorry, before you proceed. It appears that by an order dated 13 September 2021, the court has left the question of maintainability of the suit open.
Yes. That is.
What happens to that?
But
if today your suit is decreed under 13A, what happens to that?
The my lord can decide it.
What? Decide what? Why should we?
30.
This is an intra-court appeal. Unless we find that the order impugned is perverse or is wholly wrong, wholly erroneous. Remember those Supreme Court decisions? A mere error will not do. Unless we find it's wholly erroneous, why should we interfere? And it's not that you have been non-suited or your suit has been dismissed. The learned judge has just found that this is not a case for summary judgment.
Full-fledged trial is required.
Go
But
and
today,
obtain a decree.
then my second issue falls for consideration whether there should be a conditional leave to defend or an unconditional leave to defend.
That is our perception. The learned single judge's perception was
no condition.
No condition, and that is also our perception. Given the nature of issues raised, tribal issues raised.
Kindly see those.
We have seen.
Kindly see page 45A first and 128. Two documents.
Very.
At the very outset, I state that in view of the good relationship between this is a typed copy. You have been allowed to use and occupy the third floor of municipal premises number such and such for a period of 25 years in pursuance of the terms and conditions contained in the deed of lease dated such and such. You are aware of the fact that the said period of 25 years have expired on 31st October 2020, and thus you are under a legal duty and obligation to vacate and hand over vacant physical possession of the said flat to me on or before 31st October 2020. In this context, I have already written a letter to you on 3rd of September 2020 to let me know the date and time as to when you would hand over vacant physical possession of the said flat to me. You have not informed me anything in this regard as yet. As regards to the allegations made by you in the letter under reference are concerned, the same are absolutely and wholly false, incorrect, and without any basis. Save and except the rent for the month of July 2020, no further rent was paid by you. Pursuant to the aforesaid deed of lease, the lease rent was supposed to be enhanced 10% over the existing rent after the expiry of every 5 years. And in view thereof, original rent of rupees 1400, which was enhanced to rupees 1540 and further to rupees 1694, and thereafter to 1863.40 paisa, and lastly to 2049.74 paisa, which was duly accepted by the parties. So this is periodical enhancement has been going on.
We
It
have
is
seen
not
at
that
the end
the
of-
last
At
fla-
the end of the letter, you have said hand over physical possession.
Yes, and this is the breakup, that amount which was paid by him, 11,180.40 paisa. That was the rent for the month of July and the differential amount. And at the end of that letter, we give a detailed account of this is the amounts which are due from you. Now kindly come to page 128.
When did you transfer that money?
Before that, Lordship was correct. This is only after receiving the letter they talked about the proposal. First notice, if Lordship sees, my Lord,
Kindly see one.
First notice says nothing, which is at page 39. This story of adjusting or enhancing, my Lord, or the rent comes after I wrote the letter of 14th October.
No, this is a,
Yes,
this
yes.
comes, that letter comes, my lord, after the letter, I write a letter on page 39 that this is the date when the lease is going to expire. Kindly let me know when you are going to hand over me the possession. Kindly see the letter.
Then you accept the money.
No,
I wrote
kindly,
a letter.
kindly
After
see
that, you talked about
39,
enhancement.
page 39.
We have seen.
39 in terms of the lease granted to you in
We have seen.
this. Now, kindly see, come to page 128.
Yes.
These
We
are
see.
the counter receipts
Yes.
which have been issued upon accepting the note, the money, this check. First money is for the differential, and the second receipt is for the rent for the month of July 2020 within the list.
Other document?
These two documents.
Any other document?
No other document.
Issue. This appeal is directed against a judgment and order dated February 12, 2025, whereby the appellant's application for summary judgment under chapter Roman 13, capital A of the original side rules of this court, was dismissed by a learned judge of this court. Stop. Paragraph. It is not in dispute that the respondents were, and they claim that they still are, tenants in respect of the suit premises. Stop. We have seen the concerned lease that was executed in the year 1995. Stop. The lease was for a period of 25 years. Stop. That period expired on October 31, 2020. Correct me factually if I go wrong, Mr. Dotto, Mr. Dev. Stop. Paragraph. The appellant filed CS number 36 of 2021, claiming a decree for eviction of the respondents from the suit premises and other reliefs. Stop. After the respondents / defendants entered appearance in the suit, the appellant / plaintiff took out a summons for summary judgment, contending that the defendants have absolutely no defense and the facts of the case disclose no triable issue. Stop. According to the plaintiff, it is an open and shut case. And therefore, a full-fledged trial is wholly unnecessary. Stop. Paragraph. The learned judge recorded the respective contentions of the parties. Stop. The learned judge noted that the defendants contend that even after expiry of the lease by a flux of time, comma, the plaintiff accepted rent from the defendants. Stop. Therefore, comma, the defendants have become monthly tenants or at least tenants by holding over in respect of they claim. Their case, the learned judge has noted. This is what we are saying. By holding over in respect of the suit premises. Stop. The learned judge also noted that by an order dated December 13, 2021, a learned judge of this court kept the point of maintainability of the suit open. Stop. The defendants contended that if the suit is decreed summarily, that order would become infructuous. Stop. Paragraph. The plaintiff, however, contended before the learned judge that no rent was received by the plaintiff from the defendants after expiry of the lease on October 31, 2020. Stop. The money that was transferred by the defendants, in the sum of approximately rupees 11,000, consisted of rent for the months of July and August 2020.
June 2020, July to December 2020. That's our contention.
Your contention, they are saying July and August and enhancement. July and August 2020 and
July. Only July?
July.
July and the differential amount of the 10%.
And the differential amount of enhanced rent in terms of the 10% enhancement clause in the lease deed. Stop. The defendants, of course, contended that the said sum of approximately rupees 11,000 was tendered on account of rent for the period July to December, 2020. Stop. Paragraph. The learned judge referred to various authorities, including the referred to various authorities cited by the parties, including the decisions of the Honorable Supreme Court in R.N. Gosai. শোনো, এই internal page 6 থেকে আমি টিক করে দিচ্ছি, সেটা করে দাও এগুলো। comma, ছটা আছে, which were relied upon by the defendants. Stop. Finally, the learned judge came to the conclusion that the defense raised by the defendants is a reasonable one, is a fair and reasonable one, and therefore unconditional leave should be granted.
However, there should be condition. They should deposit the 1300 square feet on-road property. They would
Mr.
be
Dotto, you have made your submission. We have heard you. Allow us to.
some condition. Occupational charges should be deposited, not with me, that it will be deposited with the registrar also.
Leave should be granted to the defendants to defend the suit. Stop. Accordingly, the learned judge dismissed the plaintiff's application for summary judgment. Stop. Hence, this appeal at the instance of the plaintiff. Paragraph. We have heard Mr. Dotto, learned counsel representing the appellant at some length. Stop. We have not called upon Mr. Deb, learned senior counsel representing the respondents. Stop. Paragraph. We have noted the respective contentions of the parties advanced before the learned single judge. Stop. We have noted above, Koro. Stop. In our opinion, the issues raised by the defendant need to go to trial. Stop. The defense raised by the respondents cannot be said to be moonshine so as to disentitle the defendants to contest the suit. Stop. Paragraph. Mr. Dotto says that some condition should be imposed on the defendants and unconditional leave ought not to be granted. Stop. We cannot agree with him. Stop. We would have imposed conditions if we had serious doubt about the defendant's good faith or genuineness of the triable issues. Stop. We cannot say that the defense is wholly improbable. Stop. We cannot say that there is no genuine triable issue. Stop. Hence, we are not inclined to impose any condition on the defendants. Stop. Paragraph. In view of the aforesaid, paragraph, we cannot lose sight of the fact that this is an intra-court appeal. Stop. The appeal court will not interfere merely, even if the learned single judge's order is merely erroneous. Stop. Merely erroneous according to the opinion of the appeal court. Stop. It is only when the order is wholly erroneous or perverse that interference is called for. Stop. That is not the case here. Stop. The view taken by the learned single judge is definitely a plausible one. Plausible and probable one. Stop. Paragraph. In view of the aforesaid, we see no reason for interfering with the order under appeal, which accordingly stands dismissed. Stop. There will be no order as to
Let
costs.
there be a direction that let the defendants deposit the last paid rent with the registrar. Because he's occupying the
Sorry?
property from 2020.
Are you not? He's paying rent, aren't they paying?
Nothing.
No, he has not
2020 till
accepted that
2025, he's not paying anything. He's occupying a 1300 square feet free.
After what date he is not paying anything?
That's 11,000. That's the last paid rent, August 2020, and thereafter nothing. And he's enjoying the
Get
property. He's
excited.
enjoying the facility.
Don't get excited. It's not your personal case, Mr. Dattu.
No, he's enjoying the property.
You know what
man.
excitement does? Raises blood pressure. You know, a lot of other things. So don't do that to yourself. আচ্ছা, লেখো তারপরে। After this order is dictated, Mr. Dotto says that the defendants are enjoying the suit property without paying anything since January 2021.
No, from that's last paid rent is July 2020.
He's going by his own letter.
January, if it's by
Undisputedly, it's January 2021. Stop. We direct the defendants to pay the rent oblique occupational charge at the agreed rate.
If not paid, my lord, I am
not at the agreed rate, my lord, last
Not
paid
paid,
rent, my lord.
At the last paid rate.
Yes.
At the last paid.
Absolutely.
At the rate last paid. At the rate last paid. For the period for which the same remains unpaid, within 2 weeks from date. Stop. In case the same is not done, the appellant will be at liberty to mention the matter before us.
Deposit with the registrar. They will be deposit. No, we will deposit with the register without prejudice.
Deposit
This amount with the registrar.
Deposit with the registrar, original side, without prejudice to the rights and contents.
And my lord has recorded that they are not paying since January 2021. If that statement observation goes, my lord, that my lord implied they will constitute that it has been till December rent has been paid.
For a long time.
For long.
We would calculate and deposit. But only
2,500, please.
I know, but I had no instruction. Probably we paid and subsequently they refused. This is my instruction. Wholly on instruction, I'm saying.
Deposit.
Otherwise, there was no reason not to pay.
Now that we have said deposit with the registrar, deposit with the registrar.
The registrar will invest this amount. Whatever amount comes in, they will deposit in a short-term deposit, my lord.
Disposed of হয়ে গেল, but paragraph. This matter shall be listed again 2 weeks hence, only to record compliance.
Instead of 2 weeks, Lordship gives us 3 weeks time.
3 weeks করে দিও ওটা, within 2 weeks বলেছিলাম, 3 weeks করে দাও. Shall be listed 3 weeks hence, only to record compliance of this order by the defendants, by the respondents.
And last submission, which my learned friend will certainly not oppose, my lord, that since my lord is sending the suit for trial, my lord, let the hearing of the suit be expedited.
Paragraph, the hearing of the suit is expedited. Stop. Written statement filed. Discovery?
No,
no. There'll be an order for cross discovery within 3 weeks from date. Inspection forthwith thereafter. Stop. The parties will be at liberty to mention the matter for hearing before the learned single judge once the suit is ready for hearing.
I will complete it within 6 months or 1 year.
No.
Grateful.
That 2000?
অ্যাপ্লিকেশন ছিল কিছু সঙ্গে না আমি কি
Appeal from order item number 12.
It's my appeal, my lord.
Let Mr. Ghosh is online. He is leading him. Mr. Pradeep Ghosh.
Online becomes very difficult, Mr. Dotto.
But perhaps he is unable to come.
Yes. Whose appeal is this?
My appeal.
I'm here, Miller. I'm appearing for the respondent.
Yes, Mr. Ghosh.
But so this appeal, my lord, arises out of, my lord, an order passed in a section 34
Is
application.
this GA, Mr. Ghoshal?
I'm sorry, my lord, I'm unable to appear before
GA1, if lordship is.
appear before a lordship because of personal, my lord, physical ailment. Now today.
No, but will you, Mr. Ghosh, will you be able to appear personally, physically, if we adjourn the matter for
But
any
the
number
point
of
is,
days?
I fell down. I broke
Yes.
my hip joint.
Oh,
So I had to be operated. I'm much better now. I'm going about with stick, but I can't, I require help to go around. That's why I'm not being able to attend.
very well. The only difficulty is there's this connectivity issue.
Yes.
And it's not always, this communication is not always very clear. So we could, unless Mr. Ghoshal objects, we could adjourn this for 3 or 4 weeks if you like. If you think that after that you'll be able to attend physically.
I think so. Well, I think so. Because the way I'm progressing, it should be. From wheelchair, I've gone to walker, now I'm on stick.
May I say this, my lord? May I start, my lord? My instructions is, my lord, this is a matter pending for some time, my lord, and stakes are pretty high, my lord, and it's facts are pretty checkered. I will take some time, my lord.
You may take some time, but the whole idea is better for us if Mr. Ghosh is physically present. And we said so. Why? We said so because often there is interruption.
I understand, my lord.
Yes. Mr. Ghoshal, at times you have to use.
I always never stand in the way.
He never asked for it.
I never, Mr. I just sit next to Mr. Ghosh, so I dare not, my lord, object him, my lord, but I understand, my lord.
We'll adjourn it for 4 weeks, and let us hope that after that he is able to come.
Fair enough, my lord.
Okay, I have never asked for any
No, we are not recording that you have asked for any adjournment, Mr. Ghosh.
earlier, my lord. It's unfortunate, my lord, this accident happened.
Yes. In view of the fact that learned senior counsel representing the respondent is convalescing and recovering after a surgery, although he is present on the virtual platform today, we deem it appropriate to adjourn the matter for 4 weeks so that he can appear before us physically. Paragraph lists this matter once again. Date dao on July 9.
Fix that. Let it retain its position, my lord.
Retaining its position.
And my lord, one line of objection, my lord. It's just for the records, my lord, that I had to.
It look very bad.
Looks very bad. I know, my lord.
Use your, as I said, use your counsel's discretion.
I would.
Don't do it.
In fact, I'm missing Mr. Ghoshal's company also. I can text to him.
I miss his company too, my lord. It's been a while that Mr. Ghosh has not been able to come.
Very well.
Item number 13.
Deeply obliged.
Grateful to your lordship.
Yes.
I appear on behalf of the respondent. I am led by Mr. Subhusati Chaudhary.
Pass.
Dear Lordship, I'm for the appellant.
Yes.
That I'm paying for a short passover. I led by Mr. Auric Banerjee. He is engaged in.
Pass over.
14.
14, I had something to do with this matter?
That is another that has been released.
Sure.
Yes.
Lordship, in this matter, the learned advocate general was appearing and was assisted by Mrs. Noel Banerjee, Your Lordship. There has been a bereavement in the family, Lordship. Kindly
Lordship,
please, after some time.
No, there's,
and
I
then,
knew that this
No, no.
is been said everywhere.
No, not everywhere.
Lordship, this is the order passed by your lordship. I'm suffering an interim order for quite some time. We have preferred an SLP. There is a issue notice from in that order, and the Supreme Court has said,
I'm
despite
only
the
praying
fact
for
that
a
Supreme,
fortnight's time.
despite the fact that it is pending, the appeal court should proceed with the matter. And 2 orders were passed. Lordship had recognized that fact.
Who's instructing you, Mr. Shah? Who is instructing you? Somebody, a learned counsel, has lost her father.
No, I'm not on that.
Then you're on what?
Advocate General is appearing, Lordship, in this matter.
Yeah, assisted by the.
So one day,
He will appear alone.
Lordship will
We
say,
are surprised at the submission you are making.
how many
Not expected from you. Bereavement, death, father, urgent for a fortnight.
At 25th, which is
it was because I am at a very difficult thing. That is why
You made your submission on instruction. We understand. But at times you have to tell your instructing advocate, sorry, I cannot. That is the counsel's discretion. Certain things are not done.
Item number 15.
I'm for the applicant.
This was, in fact, my lord, heard by the other bench.
Oh.
Yes. Setting aside of, my lord, the ex parte decree.
Yes. It was heard substantially, I think. Hey, what file now? What we are doing, Mr. Mitro, the matters that were substantially heard, although not marked part heard, we are releasing from our list, and that will be assigned to that bench. Since Justice Rai is sitting singly, it won't be difficult for us to assemble. It's up to you.
No.
You can start afresh.
I would prefer to, my lord.
Take it. Fine.
ঠিক আছে। এখনো লিস্ট অব্দি ছিল কপি আছে এক্সট্রা কপি লাগবে তো কি ঠিক আছে On earlier occasion, my lord, I had handed over, my lord, a list of
order ফাইলটা দাও তো
জাস্টিস বন্দ্যোপাধ্যায়ের কপিটা তো আলাদা
Mr. Bagh is assisting you. No. কি দিলে এটা? এটাই তো। হুম আচ্ছা এখানে অন্য মামলার অর্ডার ঢুকে বসে আছে, কোনো মানে আছে? কি করো তোমরা না? সরি, order passed in some other matter has been included in this file. Please proceed. Yes.
On the last occasion, my lord, I had handed over a list of dates. No, I really do not know whether your lordship's copy, my lord, is eight the other fresh copy. Justice Dr. Thank you.
দুটো কপি নিয়ে কি করবেন উনি?
No, I do not know, my lord, whether it is marked, the earlier copy is marked or not. That is why, my lord, we prepared.
Marked copies are preferred. It emphasizes highlights. Yes.
May I hurriedly go through the list of dates and then come?
Yes.
Kindly see 13th November 2016, a demand notice was issued. Kindly turn the page 14th December 2016.
Is it money lent in advance? What is it?
Yes, basically, my lord, money was given for some purpose and my lord, it failed. 14th of December 2016, by email, the letter dated such and such was sent to the respondent on their official email address. The said email was successfully served. Then 1st March 2017, demand notices were sent to the respondent, which returned with the endorsement refused. It is at page 193. I shall show it. Then 8th September 2017, plaint was presented, leave granted. 20th September 2017, plaintiff filed an application for judgment upon admission. 5th January 2018, writ of summons were lodged with the sheriff's office. 6th February 2018, writ of summons returned with the endorsement refused. Then 12th February 2018, the judgment upon admission application was taken up for hearing, wherein it is recorded that the defendant has also refused to accept the service of the application, as also the writ of summons. The writ has been returned with the endorsement refused. The said application was dismissed as the admission was made in the balance sheet under long-term borrowing. Then 10th July 2018, amendment application filed by the plaintiff being GA number such and such. As GA number such and such could not be served, the appellant prayed for substituted service. 14th August 2018, by an order, prayer for substituted service of the amendment application was allowed. 24th August 2018, pursuant to the order dated 14th August 2018, advertisement published in 2 newspapers of the amendment application. 13th September 2018, by order, amendment application was allowed. 25th September 2018, the plaintiff through its advocate lodged a fresh writ of summons with the amended plaint. 27th November 2018, writ of summons returned and received by the office of the sheriff with the endorsement delivery packet marked insufficient address. 13th December 2018, by order, substituted service of the amended plaint was allowed. 23rd December 2018, pursuant to order dated 13th December 2018, substituted service by paper publication was done. 4th February 2019, by an order and in terms of the substituted service done as per the order dated 13th December 2018, the suit was directed to appear as an undefended suit 2 weeks hence. 6th February 2019, post amendment of the plaint, the writ of summons of the amended plaint served by registered post returned with the endorsement refused. Then respondent issued a notice under section 21 of the Arbitration and Conciliation Act. From the letter dated 18th March 2019, the plaintiff came to know that the defendant changed its registered office. On subsequent inquiry, it transpired that such change in the registered office took place on 11th March 2019. 26th March 2019, by notice through its advocate, the plaintiff replied to the notice under section 21 and informed that the above suit has been filed by the petitioner against the respondent for recovery of money. This date is important, 26 March 2019. This letter, my lord, they admit that they have received it. Then 24th April 2019, change of address was informed to this Honorable Court and is recorded in the order. 12th June 2019, decree passed. The appellant put the decree into execution by filing execution case number 397 of 2019. 14th November 2019, Managing Director of the respondent was directed to file affidavit disclosing the assets of the respondent. Notice was returned unserved. 12th March 2020, by an order, appellant was granted leave to issue advertisement in Central Chronicle and receiver was appointed to take symbolic possession of the whole property. 4th January 2021, the petitioner came across a public notice in newspaper Doinik Bhaskar, wherein part of the property mentioned in item number 1 of paragraph 9 of the affidavit in support of the tabular statement was mentioned for selling the same to a third party. 5th January 2021, the learned advocate for the petitioner informed to Sudhir Agarwal advocate that any sale of the subject property will amount to contempt of court order. Then the appellant was served with an application under Order 9, Rule 13 of the court. It was on 25th of January 2021. And my lord, that application was allowed. Now, my lord,
The receiver actually took symbolic possession.
no, possibly could not, my lord. Possibly could not. Yes, for COVID, my lord, possibly for COVID, my lord, no steps could be taken. Now, my lord, kindly come to some documents, my lord. Now, kindly take up the petition, my lord. Or now, paper book, take it. পেপার বইটা দেবেন My lord, in my full submission, the short point which is required to be considered in this appeal is, my lord, whether an ex parte decree is liable to be set aside, my lord, at the instance of a defendant who knew about the suit and sat on the fence. I had relied on, my lord, this.
There's an amendment, no, in the CPC? No. CPC does also?
Kindly come to Order 9, Rule 13 once.
Second proviso.
Second proviso. May I read it out? Provided further that no court shall set aside a decree passed ex parte merely on the ground that there has been an irregularity in the service of the summons, if it is satisfied that the defendant had notice of the date of hearing and had sufficient time to appear and answer the plaintiff's claim. Now, kindly take up their application. It is at page 91 of the first volume. Kindly come to the second page, page 92, paragraph 2. The petitioner states that the petitioner has come to know of passing of the ex parte decree dated 12 June 2019 by the Honorable Justice so-and-so for the first time on 5th January 2021 in the facts and circumstances stated hereinafter. Then paragraph 3. The petitioner states that the petitioner was never aware of the filing of the present suit before this honorable court at any given point of time on or before 26 March 2019. In this regard, the notice under Section 11 of the Arbitration and Conciliation Act dated 18th March and the reply of the plaintiff's advocate dated 26 March 2019 are annexed here to collectively marked with the letter B. Kindly once come to page 110.
So your reply to the section 21 notice not received by them.
They are pleading that notice.
So how do they say they came to know only on 5th January?
They came to know about this decree on 5th January, they say.
Achha, decree. But they became aware of the suit from your notice in 2019.
2019.
Yes, 110.
আসছি। Page 110, kindly come to your client, the defendant, Cloyne Infrastructure Private Limited, having registered office as such and such. Then kindly turn the page 111, but the typed copy is, my lord, page 111A. First, second, third paragraph. Accordingly, our client has instituted a suit being such, CS number such and such, before the Honorable High Court at Calcutta, entirely to claim a decree for a sum of rupees 1 crore 35 lakh along with interest thereon at the rate of 18% per annum against your client. The same is still pending adjudication. Several attempts have been made by your client for service of the writ of summons on your client. Despite such efforts, including substituted service as envisaged under Order 5, Rule 20 of the Code of Civil Procedure, your client has failed and neglected to appear or contest the said suit pending before the Honorable High Court at Calcutta. The said notice is only an afterthought to delay or to make the said suit filed before the Honorable High Court by our client infructuous. But this was very clearly stated about the suit number, and that it is pending. Then, my lord, kindly come back to the application, page 92. Paragraph 4. However, the then advocate of the petitioner, kindly take note of the language used, very carefully used. The then advocate of the petitioner, my lord, I was thinking, my lord, that who, where, in this court, somewhere else, failed and or neglected to take proper steps to follow up the proceeding of the suit pending before this honorable court. 5. Paragraph 5. As far as the petitioner was able to ascertain, the advocate did in fact try to contact several advocates in Kolkata to follow up with regard to the instant suit. However, the petitioner was always informed as and when the erstwhile advocate of the petitioner was contacted in finding out and following up proceedings of the said suit that due steps are being taken to follow up the above instant suit and to protect the interest of the petitioner. They don't appoint anybody here. Nobody is named. 6. However, it seems now that the said ex parte decree has been passed on 12 June 2019 in the instant suit and that the petitioner went unrepresented. Then 7. Upon coming to know of passing of the said decree and the pendency of an execution application being EC number such and such, wherein 2 orders dated 14th November 2019 and 12th March 2020 were passed, the petitioner immediately contacted the present advocate to find out and take steps with regard to the recalling of the said purported ex parte decree dated 12th June 2019. In this regard, order dated such and such, downloaded from the official website of this Honorable Court, are annexed here. Then kindly come to the next paragraph. Thereafter, the plaintiff's advocate wrote a letter dated 5th January 2021. Inter alia informed the petitioner of passing of the decree and pendency of the execution application before this Honorable Court. A copy of the said letter is annexed. Kindly come to page 116. না 116 না না এটা কি চিঠি page 11 sorry
Mr. Mitru, I had dealt with this matter in execution, sitting singly. Just now my sister points it out. Page 114.
Yes.
I had passed orders in execution.
Yes.
I never touch a matter in division bench which I have dealt with sitting singly. Please.
I'm sorry, my lord. I never thought that this can create any difficulty. It's, I should have pointed out, but my lord.
Yes, no. Hey, Lekho.
In execution, only thing is, my lord, the decree was not passed by your lordship.
Mr. Mitro, there may be insinuation that since I had passed orders in execution of decree, in aid of execution, tendency is to uphold the decree. Why go get into this? I'm sorry we have wasted some time, but you know, days are bad. I'm openly saying so. Days are bad, and there's nobody to defend us. We are not after we heard learned senior counsel for the appellant for some time, it transpired that one of us, bracket Aman Namtari, bracket close, had dealt with this matter in execution proceedings, sitting singly. Stop. Hence, we are not inclined to take up this matter.
May I say this?
Recording that there's no objection from any side will not help. Tomorrow the advocate will be changed. It has happened.
No, it can happen.
It has happened.
So we do not have any objections.
Take up this matter. Paragraph. Let this matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction. Vakish. Thank you. It's impossible to remember otherwise.
I never thought, because my lord, the decree was not passed by your lordship, my lord. That is why I
Yes,
thought.
but since I have passed orders in aid of execution, theoretically speaking, if the judgment debtor loses, an allegation may be made, oh, of course he will uphold the decree. Sorry. Mr. Kothari, today you are briefed, tomorrow you may not be briefed.
Item number 16.
But I am for the petitioner, not this matter, my lord.
Ma'am, for the award holder response.
This is an appeal, my lord, under section 37 of the Arbitration and Conciliation Act, my lord.
Yes.
My lord, I can start today, my lord, but only difficulty after 2 p.m., my lord, I have a fixed matter. So I can continue in the next week.
Then don't start. Don't do this. 13 minutes, 12 minutes. We appreciate, we are very happy that you are very busy. But
Not that, my lord. There is a contempt matter which is, my lord.
don't do it.
I cannot assign.
Sure, next.
My lordship, kindly fix a matter because we are ultimate in the suffering end, lordship.
What fix?
In
It will retain his
2006,
position.
in 2006, I understand the predicament of my learned friend, but the thing is that the award has been passed in 2006.
Sir, we are willing to hear it today. Your learned friend is in difficulty. What can we do?
Lord, I am starting, Lord. She will take. Lord, I am starting, Lord.
Then you will continue at 2 o'clock. Yes.
Lord, I have, my lord, earlier argued this matter before the other bench, my lord, and there is a my lord, list of dates, my lord, which must be lying in the correct list of dates.
Who is the award holder? He.
But he is the award holder. But there were total 25 number of claims in the arbitration proceeding. Out of the 25, they have withdrawn 1 claim. So that takes us to 24 claims. Now, out of that 24, 9 claims were rejected and 15 claims were allowed.
25 heads of claim.
25, they withdrawn claim number 20, so it becomes 24.
Nine claims rejected.
9 claims rejected. There is no challenge to that. That has attained finality. And 15 claims were allowed, my lord. Now, out of those 15, my lord, again, my lord, 4 claims were paid by my client during the pendency of the Section 34 application without prejudice to our rights and contention. So today, my lord, basically we are on 11 number of claims. And out of this 11 number of claims, 1 is the interest.
Why, you are not assailing those 4 heads of claim which you have paid? You are not.
No, we are not assailing that. That has been paid, my lord, without prejudice to our right. But, my lord, today, my lord, we are, because, my lord, what happened in this matter, my lord, if I take your lordship to the list of dates once, my lord, those were the amounts which were payable, which were under the final bill. But the claims which were lodged after final bill, those are basically in dispute today. But if your lordship takes up the list of dates, my lord, first entry is 9th April 1987. That is the date of tender, my lord, for 50 electric loco cells. Thereafter, my lord, the LOA was issued in favor of the respondent, my lord, for an amount to the tune of rupees 1,32,24,100. Today, my lord, I have paid him almost 1.44 crores plus the amount under claim number 124. So all the amounts which are, my lord, today claimed or which have been awarded, those are, my lord, some amounts beyond the contract. I will, my lord, my specific ground is that also that all these claims are first of all time barred. Secondly, those are beyond contract and rather not payable under the contract. So, my lord, the work was supposed to be completed by 18 months. However, my lord, it was completed within 24 months. The next entry is for agreement which was entered into by and between the parties. And the work was completed, my lord, on September 1989.
The next date is very important, my lord. On 1st of September 1993, the final bill was prepared and signed by the claimant. However, for some technical reason, the same bill, duplicate copy of the said final bill was again asked to be signed, and that was signed on 15/11/1993. So final bill date is 1993, which was resigned on 15/11/1993. Now, my lord, at that point of time, some delay had occurred in making the payment. Because we are also supposed to get the payment from the client, some delay had occurred. Now, during this delay, when the final bill was pending consideration and was supposed to be released, all of a sudden on 12/6/1996, obviously being furious with the delay, my lord, they have lodged certain additional claims, which are the subject matter of, my lord, dispute today, my lord. So that this claim, which are in dispute, that was first raised by the claimant on 12/6/1996. In view of the delay in payment, the claimant submitted demand for various other extra amounts for the first time, which were not mentioned in the final bill. So therefore, my lord, the contract was concluded on the work was concluded, my lord, on September 1989. Final bill was raised. All these claims were never, my lord, raised during that material point of time. However, in the year 1996, for the first time, they have lodged these claims under several heads. Nuts, bolts, many things are there. So your lordship can find that the contract was entered in the regime of, my lord, 1940 Act. Thereafter, my lord, Arbitration and Conciliation Act 96 came into force on 16/8/1996. And the arbitration clause was invoked by the claimant on 19/11/1996. So invocation was under the 2015 Act. Sorry, 1996 Act. My lord, thereafter, Section 11 application was filed, my lord. The learned arbitrator was appointed.
Who was the arbitrator?
My lord, Justice Manjula Bose, my lord. So arbitration commenced on 18/6/1998, and after, my lord, 192 sittings, my lord, the award was published. 216. Okay, sorry. 216 sittings.
216.
I may be, my lord, wrong, my lord. I was not in that, my lord, during that point of time. Yes. You are not even in the profession at that point of time. So the award was, my lord, 31st of December 2005. Thereafter, Section 34 was filed. And, my lord, during the pendency of the Section 34 application, my lord, 2015 Act, my lord, the amendment of 2015, my lord, stepped in, my lord. However, my specific case is that since the application was filed prior to the 2015 application, prior to the amendment of 2015, my lord, it will be guided by the provisions which were there during, my lord, that point of time when it was filed. So pre-amended provisions of the Arbitration Act will be applicable. Which, my lord, why I am saying so, my lord, because under Section 34, my lord, after amendment, the scope has been much narrowed down. So our case, my lord.
Possibly you are not right unless you have authorities, because you have no vested right to have broader, wider grounds. The law is as it stands on the day of consideration of the 34. Possibly that. Anyway, this is all
Geotechnical. I will be relying on those case laws which will not govern that. In any event, my lord, even today, even if we go by today's law, my lord, post-amendment law, even then, my lord, I will be, my lord, showing that it is against the Arbitration Act also. That I will come. So thereafter, my lord, the Section 34 application was filed, which was, my lord, which was, my lord, dismissed. However, during the pendency, as I have already pointed out before your lordship, that I have paid 4 claims.
34 was filed where?
Before this.
So take us to the. Let us read the impugned order once.
Yes.
You know what happens? The impugned order gives us an entire picture, a broad picture.
Volume 7, 705.
Much easier from the memorandum of appeal.
Before that, my lord, I would like to just point out 2 things, my lord. What happened, my lord? There were 2 references which were continuing between the same parties before the same arbitrator. And the awards were passed on the same date. Now, today, as I have mentioned at the very outset, Milord, that out of the 11 numbers of claim, the principal claim value is 33 lakhs, 33.79 lakhs. But the interest.
Your section 34 encompass both the references? No.
No, not that, Milord. Why I am saying so, Milord? Between same parties, 2 arbitrations were going on. Same arbitrator, same day award was published, and interest, both pendentalite and post-award interest was awarded by the same arbitrator. Now, both those awards were assailed in section 34 before this honorable court.
Separate section 34.
Separate section 34 before this honorable court. Milord, the contract, Milord, and the conditions which are, Milord, governing the field, Milord, almost, Milord, I am a government of India enterprise. So my contract is, Milord, standardized form, same type of, Milord, clauses are there, only the numbers are different. But in one matter, Milord, that interest part in section 34 was, Milord, set aside. And this matter, Milord, this interest has been upheld. So today I am mainly aggrieved by the interest. I will challenge the awarding of interest on two-folded ground. Number one, interest itself is a parasitic, Milord, claim which depends on the principal claims which are not payable under the contract. So that is on merit. And secondly, Milord, the contract says no interest would be payable, at least for the period of pendentalite period. So in violation of that particular, Milord, provision of the agreement, interest was awarded by the learned arbitrator. And relying on certain judgments, which were, Milord, in the regime of 1940 Act. So under the old Arbitration Act, your Lordship knows that there was no provision which, Milord, restrained the authority of the learned arbitrator to grant or award interest for the pendentalite period. But that is different in, Milord, after the 1996 Act, Milord. So on that two-folded, that is the maximum chunk of claim today, which amounts to, Milord, 1.2 or 3 crores or more than that. And the balance is, Milord, against the principal claim. So that is the, Milord, in, Milord, nutshell, Milord, the gamut of my section 37 application. So in 134, I have received an award which has not been challenged by them on the same terms and conditions, saying that award would not be, the interest would not be awarded, should not be awarded, and therefore set aside. But in this matter, Milord, award was upheld completely, thereby allowing the interest also. So, Milord, same thing, Milord, received 2 fates. And one judgment is, Milord, passed by, Milord, both are by different single judges, Milord.
My improved order is at volume 6, Lordship.
Yes, now I am coming to the
701. Starting from page 701. Volume 6.
But I have annexed, Milord, both the judgments in passed in section 34. One is, Milord, which one is impugned here, Milord, that is at page 701. And the other judgment, Milord, which has been passed, Milord, is, Milord, at page 763 of the same volume. I mean, actually.
Let us deal with the present judgment.
Yes, yes. পেপার গুলো আছে তো না পেপার গুলো আছে তো ওকে মেমো থেকে ঠিক আছে ফাইন Milord, if your Lordship, Milord, takes up, Milord, first page, Milord, deals with the nature of work, Milord, 15 elective loco seals, Milord. 18 months was the completion period, completed within 24 months. Those are there, Milord. At page number 2, Milord, your Lordship will get the claims. Out of these claims, my lord, if your lordship kindly, my lord, take a note, my lord. I have paid 1 to 4. So I will be placing, my lord, from claim number 5 onward. Claim number 5 for rupees 42,219 for refund of cost recovered for holding down bolts.
Which of these were allowed in the award?
That is the point. Claim number 5, 6, 7.
5 allowed.
5 was allowed. 6, 7.
Yes.
8, 9.
Yes.
14.
14.
15.
15.
18. 19.
18, 19.
And 25. Interested claim ta kothay? And my lord, 24 is the interest. So 24 was also allowed. Kindly mark, my lord, separately 25.
24 and
24 was allowed.
Yes, 24 was the claim for interest.
Yes.
Allowed, but not at the rate, my lord, mentioned in the claim. It was allowed at the rate of, my lord, 12%.
Yes.
If your lordship takes, my lord, page number 5, internal page number 5 of the judgment.
Your counterclaim was rejected.
In full.
Come back.
One was, my lord.
You go do your contempt.
When
No, unta fixed ache. By the time that gets over, your content may have been completed.
It is complicated.
Just see, if you are free, we'll take it up. Otherwise, it will stand adjourned for the day.
Let me come back. I'll be better equipped next time.
When?
At you, as per your lordship. As per your lordship.
Day after tomorrow?
Day after tomorrow.
তাই তো ফ্রাইডে কালকে দেখে তো লাভ নেই কোনো দেখো learned counsel for the appellant begins his opening submission but does not conclude. So upon his request, let this matter be listed again on Porshudinir date then. এই শোনো কত নম্বর হচ্ছে এটা?
Item number 16, lordship.
16. এর উপরে যেন কিছু না, এর উপরে তো কিছু নেইও, মানে যেটা শুরু হয়েছে এরকম কিছু আছে? হ্যাঁ হ্যাঁ, ডেটটা দিয়েছো? অন সাচেন্স পরশু দিনের তারিখ, ডে আফটার টুমরো লিখবে না, তারিখটা দাও। As appeals from orders.
I'm deeply
opposed.
Number 13, my lord, I paid for Passover, but Mr. Banerjee is not there in the second half. My lord, I am told to take not today.
My lord, may I be permitted?
Who is on your other side? Inform.
He's here, my lord.
I am not hearing.
My lord, the next item, my lord, item number 17, Mr. Jishnu Saha was appearing in this matter. He's not here today. I'm praying for not today, my lord. His dog is extremely sick today. Perhaps they will put her to.
Who is sick?
Mr. Jishnu Saha. He's leading in this matter,
Oh, I
my
see.
lord. So
Yes,
that-
who's on the other side? Not today.
My lord, not today, my lord.
Not today.
Not today, my lord. He'll be here tomorrow.
Not today. Yes.
But I'm very sorry, Lord, I could not assist.
No,
you,
no.
Lord,
How
in
is
the
he?
morning. Lord, he just got over, Lord.
Just got over.
I got over. I just came
Item
from
number
there.
7.
The Lordship has heard the matter in details. I'll not trouble your Lordships much. I think your Lordship has been handed over notes of arguments by both sides, convenience compilations, compilation of judgments.
Is this the territorial jurisdiction
My lord,
and scope of section 9?
Yes, more
Post award.
on the scope of section 9 in post award.
Post award situation.
Instead of saying morely, my learned friend can very well say I'm only nine. Jurisdiction is
Yes, because my lord has already
Yes, yes.
expressed
You
my
can
lord
be
my-
very brief. You can be very
And on last occasion also, I also indicated while submitting that since jurisdiction, my lord has asked me, that's why I'm addressing it first. But however, my main point is on the scope.
All right.
But 4th November 2023, Lord, the earlier division bench has been pleased to pass an order of injunction in the appeal that substantially protects the rights of the parties insofar as the immovable property is concerned at the present moment. And perhaps there is an order of injunction restraining third-party interests from being created.
So you are saying section 42?
No. Section 42 is there because of orders in section 9 passed before the award.
Right.
I'm saying in this appeal, my lord, the division bench.
Oh, in this appeal?
This appeal. The division bench has also passed an order on 4th of November. If your lordships kindly have a look at that.
Yes.
That might, Lord,
Lord,
shortening, Lord, the...
Just make, remember to make submission on the division bench judgment of the Madras High Court authored by...
Luckily, my lord, it's only got persuasive effect now. If at all.
Could be distinguishable also.
No, that's actually legislating. If I may now have the courage to say so.
You're on YouTube.
Oh, no.
দেখো পাচ্ছ নভেম্বর কি অর্ডার বলছেন উনি ফাইলে পাবে তো এই অ্যাপিলেই হয়েছে অর্ডারটা 3rd November?
3rd November, though. 4th November, 2025, 2024. Lord, bench of Justice Shobhan Sen and Justice Apurva Sinha Roy. Lordship comes to second page. In the meantime.
Yes.
Lord, now, Lord, there are a lot of conflicts with regard to what in the meantime means. In the meantime, Lord, has been construed by courts differently. It means till the next day that the matter is taken up. So I would beseech your lordships to whatever way, in whichever way your lordships would feel
to extend
proper, to extend it till your lordships ultimately deliver judgment in the matter, and of course continue this even thereafter.
We are sure Mr. Goa will not object to
Yes,
that.
on last occasion also, it was a candid submission on my behalf that injunction to an extent schedule is that has already been granted and my client is not dealing with it.
When we record an order today, we'll extend it. So make your submission.
Now, Lord, this relates to a partnership action where, Lord, the partners have 50% shareholding. Lord, the basis of the partnership is that, Lord, the appellants being the Mohapatra family. Initially, it was the father, mother, two sons. Father has expired. Now it's mother and two sons. They would have 50% of the share of the profits and losses. They would bring in the property. The property was about, Lord, 14.71 acres of land. They would bring in the property as part of their capital. We would infuse funds, Lord, we would develop the property, promote it, and Lord, from the sale, Lord, it would be divided in the percentage of 50 and 50. Now, Lord, insofar as this partnership is concerned, one of the main issues under consideration is whether it was a partnership at will or not. Lord, so far as the partnership is concerned, the partners were proceeding in right earnest until the father Mohapatra passed away. Father Mohapatra is Tarokanto Mohapatra, who passed away on 27th of November 2006. Thereafter, there were difficulties because the partnership agreement provided that there would be one representative from our side and one representative from their side who would coordinate the matters, who would jointly operate the bank accounts. But thereafter, we found non-cooperation. As a result of which, we wrote them letters requesting for cooperation. In return, they threatened dissolution. It is the letters threatening dissolution are 23rd of October 2007. Lord, your lordships will find these letters as part of the paper books. Lord, in fact, Lord, they are in volume 1, page 79A onwards. Each of them, there are 4 of them, they've written separate letters, all of them the same date, 23rd of October 2007. This is page 79, capital A of volume 1. Lord, this led to our notice under section 21, leading to arbitration. Now, Lord, prior to arbitration, Lord, we instituted proceedings in this honorable court under section 9, pre-reference arbitration proceedings. And your lordships will find, Lord, that in some of the orders, a large number of applications under section 9 have been adverted to in connection with section 42. But I'm for your lordships convenient because the orders are spread all over the place in the paper books. Lord, we've prepared a compilation of all the APs and the orders chronologically. Lord, I'll just indicate some of the more relevant orders for your lordship's convenience. If your lordship first takes page 1, the typed copy being at page 2, this is the first AP 376 of 2007. Your lordship will find that leave under clause 12 of the letters patent was granted on 10th December 2007. Now, this is on the section 42 jurisdiction aspect, Lord. Leave under section 12 was granted. And third paragraph, your lordship will find third party rights. An order of restraint was passed on the parties from creating third party interests.
Yes.
Then at page 3, 8th of January 2008, your lordship will find third paragraph. The application was disposed of, order dated 10th December 2007 is confirmed. So, the jurisdiction of the court issue stands concluded by this order.
Yes.
Then, Lord, we filed a second AP. Your lordship will find in the first paragraph of the order of 8th of January, there is reference to proceedings before the civil judge senior division Bhubaneswar. Now, this is not in connection with the arbitration. There's an inter-se proceedings with regard to partition amongst the Mohapatras. But no, if your lordship please comes to page 6, that's the second AP we filed. AP number 228. Your lordship please have a look at the second paragraph. The case of the petitioner is that by the order dated 8th January 2008, the order restraining creation of third-party interest was confirmed. In spite of such order, the respondent number 2 has trespassed the sites along with 2 other persons, threatened security guards with dire consequences. Complaint was lodged. Now, please come to the last paragraph. Having considered the facts of the case in view of the order dated 10th December 2007, being confirmed by the order dated 8th January 2008, the order of status quo passed in CS number such and such warrants appointment of receiver, and a receiver has been appointed at page 7. Lord, after this order was passed, there was the vacating application which was adverted to on the previous occasion by my learned friend. Lord, this is the order passed by Justice Banerjee on 8th of April 2010, page 8, where they applied for vacating on the ground of territorial jurisdiction.
Yes.
If your lordship please turns to page 14 of this compilation, this GA 2570, which was for vacating the interim orders on the ground of territorial jurisdiction, this was dismissed. Page 14.
Yes.
Middle of the page note, in such circumstances, vacating application being G number 2570 of 2008 is dismissed. No order as to cost. To AP number 228 of 2008 is a subsequent petition under section 9 of the 1996, in which an interim order dated 6 May 2008 is subsisting. AP number 228 of 2008 disposed of by confirming the interim order. So that concluded jurisdiction twice over. No appeal from this order passed by Justice Banerjee. So in my respectful submission, there is no further dispute which can be raised with regard to jurisdiction. In view of the first order, leave under clause 12, being granted, being confirmed, challenge to jurisdiction, being rejected, no appeal.
No, what Mr. Guo had argued is that in a subsequent order.
I'll come to that. I'll come to that. So by virtue of the first AP, by which leave under clause 12 is granted, confirmed, the second AP where jurisdiction was challenged, repelled, Lord, section 42 is attracted. Then, Lord, if your Lordship please comes to page 16, that's the
Yes, that's the one.
Fourth AP.
Yes.
5th December 2013.
Yes.
There, Lord, receiver was directed to take appropriate steps. Your Lordship will find in the first paragraph. Receiver is permitted to take appropriate steps in accordance with law, including complaining to the police authorities. Lord, please turn the page to page 17. This order is made without prejudice to the respondent's contention as to the maintainability of the petition in this court. Though previous section 9 petitions in respect of the same arbitration agreement have been entertained by the court. So, Lord, it was expected that this issue of territorial jurisdiction, the maintainability issue, would be canvassed in AP number 1181 of.
That was not pressed.
That was not pressed. Your Lordship will get that at page 18. 20th March 2014. At page 18, your Lordship will find 20th March. Parties agree that no further order need be passed on this petition under section 9 of the Arbitration Conciliation Act 1996, save confirming the subsisting order of injunction till disposal of the arbitral proceedings. This is res judicata.
Very well. Enough on jurisdiction. Now section 9.
Now, Lord, then, Lord, we come to, Lord, the award. Now, Lord, in the award, there are two aspects that I'd like to show your Lordship, because perhaps submission has been made that there's not much that we have got in the arbitral proceedings, which needs protection. And one judgment was cited that the losing party, the party who gets nothing, cannot seek protection in a post-award section 9. That's the Bombay judgment. Now, Lord, here in this arbitral proceedings, what we had sought, having regard to the fact that there was a threat of dissolution of a partnership which is not a partnership at will, the principal prayer was for a declaration that this is a partnership which is for a specific undertaking and not a partnership.
So therefore, the arbitrator has now held that the agreement, in effect, the agreement subsists.
Yes, Lord.
So therefore, you want to protect the land.
Lord, the arbitrator has given twofold declarations. One is A, that it is not a partnership at will. Threefold declaration. Secondly, is that the partnership is for
specific purpose,
construction, promotion, and marketing of a residential housing project. And thirdly, there's a declaration that Schedule A land is the property of the partnership. Because all along it was being contended that the property is ours.
So you want protective orders of
protection over the property, number one.
The award has not been challenged.
Has been challenged by them and by us.
And by you.
They have challenged the award in the local district court at Khurda. Although they contend that it is Bhubaneswar courts which have jurisdiction. Jurisdiction issued, I'm not troubling your lordships. They've filed a section 34 application in the district court at Khurda. We have filed an application there saying that Khurda court does not have jurisdiction.
And you have filed an application here.
We have filed an application here to the effect that our claim for money reliefs in respect of damages has been rejected. Now, so far as the partnership is concerned, it stands now established that it is a partnership which is to continue until completion of the undertaking. What is the undertaking has been clarified by the arbitrator. That it is for, the arbitrator uses these words, development, construction, promotion, and marketing. I'll show your lordship the paragraph where the arbitrator uses these 4 words. And secondly, which is very important, says that the property is the property of the partnership. So, my lord, ultimately, in enforcement of this arbitral award, I would really, my lord, beseech your lordship to hold that what we are now is at a position in the partnership where it has been held that the parties are entitled to and should continue with the project until it is completed. Now, my lord, so far as protection is concerned at this stage, in respect of the award which I have already got, is A, protection by way of injunction, restraining them from creating third-party interests, because it has been held that it is not their property, it is the property of the partnership firm. Secondly, my lord, what has happened is that because of the long lapse of time, my lord, the partnership was formed in 2004. My lord, because of long lapse of time, governmental permissions and clearances have lapsed. Those had been taken and were in place, but they have lapsed. So, my lord, we had applied to them to come and confirm the permissions that we are seeking for validation of these permissions, which they refused to cooperate. So we brought it to the notice of the Post-Award Section 9 Court, and the Post-Award Section 9 Court felt it desirable to appoint a special officer for the purposes of taking these forward. The third aspect was that the bank account operations under the partnership agreement was to be done jointly by one of our representatives, one of their representatives. They were refusing to cooperate. So the Post-Award Section 9 Court has said, very well, the receiver who is already appointed, he will undertake joint account operations, but every transaction will be upon notice to the parties. And fourthly, my lord, what has happened is all these governmental permissions that we were seeking revalidation of required us to submit title deeds. Now, my lord, this is a 14 acres of land which they have acquired from several, my lord, landowners. The original title deeds were with them. So, my lord, the order which has been passed is that the original title deed should be kept with the special officer. This is also in aid, because all the judgments in Post-Award Section 9 applications say that this is to protect the fruit of the award in aid of subsequent enforcement, but in the meantime to protect the fruit of the award.
That you asked for by way of a GA, I think.
By way of a GA. In the AP.
In the AP.
So these are the only reliefs we have got, and the court has recorded our undertaking that this is all that we will seek. Any further relief that we seek would be enforcement. We will do that by way of execution proceedings.
Only other point, which Mr. Go argued, if you want to address us, is that once an arbitral award becomes final, attains finality, the reliefs, any relief that the award holder may want, should be by approaching the execution court. And an application under Section 9 would not lie, although the wording of the section says that it would.
Until it is executed.
Until it is executed.
Now, not various situations can arise when one party may need to approach the court only for protection of what it has got. Now, Lord, if I'm approaching the court for execution in terms of Order 21, I would get orders by way of either sale or blood attachment or blood civil imprisonment or blood enforcement over bank accounts. Now, Lord, nothing in Order 21 would aid me in protecting the property over which, Lord, I have got an award today. Now, Lord, the sort of the award that I have got, I'll show you, Lordship, those 2 paragraphs only. This actually, Lord, creates a situation where the parties really are now required to take the project forward. With the protective umbrella.
To what extent their participation is required for that?
The
work you are
not
doing.
Required insofar as the construction is concerned, the development, the promotion, etc. Their participation was required only for validation of the permits and obtaining the title deeds and for the bank account operation.
Now the receiver will be doing all that.
Now, Lord, if there's any hindrance in the development, which is not the enforcement of the award that I have got, I would have to seek injunctions in terms of, Lord, Section 51 read with Order 21 of the Civil Procedure Code by way of restraints on them, which can also be given by Order 21. But these protections that I have got today, perhaps not Order 21 cannot aid me. Now, Lord, so far as the judgments cited by my learned friend are concerned, Lord, if I may may I show your Lordship the two paragraphs of the award, which I'll forget, Lord. If your Lordship please comes to the award. Your Lordship permits me to indicate from the paragraph numbers. Your Lordship is seeing from the convenience compilation or from the paper books, Lord?
Award. A counter page 23.
It's part of their convenience compilation also.
Well, it's convenience. It says page 23 of convenience.
Okay, to please eta dekho. Paragraph 87. Paragraph 87. The Lordship is pleased to come to page 75 of the convenience compilation. Running page 75. It is no. I'm sorry, let's page 74. The last 5 lines, that's the first declaration that we have got. It is held that your Lordship may have been shown this.
Page 74.
Page 74 of the convenience compilation. This is the just above paragraph 88 of the award.
Oh.
Just above paragraph 88.
Yes.
The last 5 lines. This is the first declaration that we have got. It is held that in view of the specific prescriptions in the partnership agreement, that is clauses 3.4, 3.11.1 and 3.14, and the suspicious circumstances surrounding Form 1 submitted with the Register of Firms, the partnership is not a partnership at will and was constituted to carry out a specific undertaking. The point for determination is accordingly answered. This is because if your Lordship sees the paragraph 77, this is how the arbitrator has framed the fundamental point for consideration. Paragraph 77, if your Lordship please sees, and the arbitrator has answered this in this way. The first sentence of paragraph 77. This is page 66 of the convenience compilation. The basic, fundamental and pivotal point for determination is whether the partnership in question is a partnership at will or was constituted for carrying out a specific undertaking. Now, this determination perhaps cannot be executed by an execution proceedings in terms of order 21. So I have to get interim protection subject to subsequent orders of injunction that I can apply, but in section 9. Now, the second declaration that I have got, your Lordship will find in paragraph 95. This is against me and saying that I do not get an award for damages in view of the fact that it's a continuing partnership. The Lordship please comes to the last portion just above paragraph 96 at page 78. Further, in view of the most vital plea that the partnership is continuing, there is no scope for making any claim as damages for any amount purportedly infused as capital. The question of settlement of accounts stage primarily arises at the time of dissolution or termination of the partnership or partnership coming to an end in terms of the partnership agreement, which situation is not pleaded case of the claimant. So, it's a continuing partnership. Therefore, there's no question of damages being awarded by one party to the other. That's the finding of the arbitrator. This is subject matter of challenge under 34. Thirdly, if your Lordship please comes to paragraph 96, the very next paragraph. The first 4-5 lines. Insofar as the claim that Schedule A and Schedule B lands are partnership properties is concerned, Schedule B lands being partnership, we had given up because conveyance had not been done in respect of Schedule B. The position is clear that the partnership was for a specific undertaking, that is development, construction, promotion and marketing of a residential house project for Schedule A lands. So now this declaration that the partnership was for a specific undertaking and this is the purpose being specified, again is not something which I can execute. And not the last one, if your lordship please, sees the sentence immediately thereafter. The materials on record as analyzed supra clearly establish that Schedule A lands was property of the partnership. So now these are the declarations I've got. Now these declarations, even if not executable in terms of Order 21, do not make the award otherwise fallible. So, Lord, in my respectful submission, Lord, the circumstances made it imperative for me to seek protection of the post-award Section 9 court, even before the Section 34 applications filed by both parties could be disposed of. Now, Lord, so far as the judgments are concerned, if I may take them sequentially, the first judgment being the Supreme Court judgment of 1973. This your lordship will find in volume 2 of the convenience compilation at page 179. 1973, volume 2, SCC 484. Prakash Chand, page number 179. 179 of volume 2.
That is on the point that a declaratory decree or award is also executable.
If there are parts in the declaratory decree which make it executable, like here in this case,
I wouldn't worry about those judgments. Madras Division Bench.
The Supreme Court judgment actually related to the decree where part was declaratory and part was a direction to take possession of land. Now, so far as the Madras judgment is concerned, if your lordship please comes to page 163 of the convenience compilation. Now, there are two parts to this judgment. So far as the extent of the post-award interim measures that can be granted or not are concerned, we have no quarrel with the extent of the protection which the Madras High Court has laid down are permissible. Because the Madras High Court has said that, however, if your lordship please takes paragraph 7, matters such as discovery of assets, which is garnishee under Order 21 Rule 46. Obviously, in Section 9, I can't get that. That is not an interim measure of protection. And if your lordship sees page 164, right at the top, second line, to the extent that a post-award application for interim measures may be regarded as something in aid of the award by way of its enforcement, the doors of a court under Section 9 of the Act will be open to an award holder till such time that the award becomes enforceable. One part is exactly what we say, that the doors of the court of the Section 9 must be open in aid of the award, which is what I'm asking for. The court concludes by saying till such time that the award becomes enforceable. Now, award becomes enforceable at the time when the Section 34 application, if not made, period of limitation has passed under 34 Section.
Let us say after 120 days.
After 120 days. Again, 120 days is little here and there because it's actually 3 months and 30 days and all those calculations coming. 120 days. Or if it has been made, it has been rejected. Or in circumstances where there is an application under Section 36, subsection 2, and there is direction for furnishing of security, security has not been furnished. In cases where it can be valued in terms of money, as in the case of Order 41 of the Civil Procedure Code. Here, both of us have filed applications for setting aside the arbitral award. They have challenged the entirety of the award insofar as the declarations which the arbitrator has given, which I've shown your lordship. We have challenged the award insofar as the rejection of our claim for money is concerned. When both parties have challenged the award with regard to two different aspects, but in my respectful submission, the distinguishing feature here between this case and our case is the award per se is not executable also in our case.
It has not yet become enforceable.
It has not yet become enforceable under Order 21 of the Civil Procedure Code. Particularly in our case, when I say, Lord, as my first and predominant point, reliefs I am seeking under Order 9 are not orders that I can in any case obtain by way of execution. So this is that part of those categories of awards or decrees which are inherently inexecutable. Declaratory decrees which are inexecutable. There this proposition will not apply.
Yes.
So, Lord, I make three distinctions. One is that this is actually reading down of the statute. This the matter did not call for judicial legislation, which perhaps the court has gone into. Secondly, in our case, it does not apply because it is distinguishable, because I'm saying as a matter of my principal case that the protective umbrella I'm seeking is in relation to matters which I cannot approach the court under Order 21 at any point of time, even after 120 days are over. And Lord, thirdly, Lord, in any case, Lord, so far as the quality of the orders that can be passed under Section 9 is concerned, Lord, the court was only concerned with garnishee proceedings, which is specifically covered by Order 21, Rule 41.
Hearings. Anything more, Mr. Go?
Just a very short reply, because my learned senior friend has just tried to.
Only 1 second. We are not asking you to file written notes, but since your learned friend has filed, you have filed written notes.
Actually, the direction they have also filed.
Oh, you have also filed.
Before the earlier bench,
I see.
both of us had filed.
I আছে দেখে নাও তো তোমার খাতায় আছে ফাইলে আছে তো.
And in fact, Lord, the point of Section 42 is quite succinctly covered in BGS SOMA, which my learned friends have put in their convenience compilation. In paragraph 51, Section 42 is very nicely covered, saying it would not apply. Section 42 would apply, and the issue of seat and all that would not apply in a case where Section 42 has been invoked first in point of time, before all these issues have come in. Because here, Lord, we had approached the court before the arbitral proceedings had commenced. So Section 42 came into operation then itself. The issue of a particular court having jurisdiction arose later. Lord, this aspect is covered in paragraph 51 of Lord the BGS SOMA judgment. Lord, we've referred to that in the note. And we've given several judgments, 4 or 5 of these Honorable Supreme Court with regard to the scope of power under Section 9 in post-award proceedings. That is in aid is to protect the fruits, Lord, words to this extent, which your lordship said.
Why do you refer to so many judgments? Just to make us work. All right, thank you. Yes.
My lord, this jurisdiction reply I'll come at the end, because 2 minutes reply on jurisdiction. But to an extent, this post-award Section 9, what my learned senior friend has submitted, that the award that they have got is inexecutable, or the relief that they have sought for in a Section 9 application, they cannot seek those relief under Order 21. My lord, may kindly take Order 21 once. Because they have confined their argument stating that we need a protection over the Schedule A property, and a receiver needs to be appointed so that the documents can be executed. These are the two things that they have sought for. My lord, kindly take Order 21 and kindly take Rule 32 once and thereafter Rule 34. 32.
Thirty-two and 33.
34, my lord. 33 is for restitution of conjugal rights. 34.
Very well.
The executing court is completely empowered, and order 21 completely provide this kind of relief what they are seeking for. In before a section 9 court, executing court has all the jurisdiction to grant those reliefs. So it would not be appropriate to submit that the reliefs that I am seeking for only a section 9 court can grant.
What do you say to the point that since the two section 34 applications are pending?
Yes. Now, my lord, I am coming to that part. First and foremost, my lord, my learned senior friend's client has also preferred a section 34 application, wherein they are aggrieved by a part of the award, wherein the damages as well. And we have preferred the section 34 application on the ground that the arbitrator has failed to appreciate that the basic pivotal point in the entire reference was that the contribution from my client's end and their client's end, it was a precondition that I will be investing the land, that is my 50% contribution, and their condition was to bring in infused capital, wherein the arbitrator has failed to consider that they have failed to prove that there has been any kind of capital contribution. So the declaration that has been given by the learned arbitrator is perhaps incorrect, because they have, since they themselves, the arbitrator has recorded that their capital contribution which is there.
That the section 34
So
could be
that
decided.
we have already challenged. So both the parties have already challenged the 34. So more so on the same award, on one hand, they are challenging the award. On the other hand, they want a protection under the award. But if I take the point of severability also, say for instance that if my learned senior friend comes and argues, no, a part award can be challenged, a part award can be enforced. But very carefully, they are never saying, taking this point, that yes, a part award can be enforced. They have said that we have got nothing under the award to an extent apart from the declaration. Declaration cannot be executed. Award, declaratory award cannot be executed. Hence, I need an aid under section 9. But my lord, from this order 21, I have tried to demonstrate that the relief that they have sought in a section 9 application, those reliefs are already available to them under order 21 as well. Second point is that, my lord,
Is there an award here for execution of a specific document?
no, what they are saying it's a consequence. But what relief they are seeking for? Now, my lord, kindly see the prayer they have sought for. The prayer they have sought for is the custody of the original documents of the deeds. My lord, if an award has been passed, they cannot get something which has not been granted in the award. If an award has been passed only to the extent that yes, it is for the specific purpose, and to the extent that Schedule A belongs to the partnership firm. If they need any consequential relief, they have to go before the executing court. They cannot come before the section 9 court and ask for a direction that you compel the respondent to deposit the original title deeds. Second is that, my lord, to an extent, they have not responded, at least to the main point that we have raised, that when the award has been passed in 2020, after 1 year, after the elapse of that 120 days, after 1 year in August 2021, they have approached the section 9 court, and till 2024, they have only been before the section 9 court without even going before the executing court.
So when was the section 34 filed?
My lord, ours was filed well within time.
Then how could they go before the executing court during
because
pendency of your section 34?
in pendency of this, first and foremost, in our execution 34 also, there has been no stay, there is no 36. In their one also, there is no stay of the award. But they themselves are seeking, on one hand, they themselves are seeking the benefit of the award. On the other hand, they are seeking an execution. So they have to decide first whether they are aggrieved by the award or they want a protection under the
Very
award.
well. Anything more?
And my lord, to an extent, the jurisdiction is concerned, they have relied upon this subsequent judgment of 20th March 2014, wherein they have stated that when this AP was ultimately disposed of, this issue was not raised. This is their submission. My lord, may kindly take that order, the first paragraph. The parties agree that no further order needs to be passed on this petition under section 9, save confirming the subsisting order of injunction till disposal of the arbitral reference. The parties also indicated that they will withdraw their rival nominees named as arbitrator, and the respondent would withdraw their request under section 11 of the act lodged before the Chief Justice. The parties agree that R.K. Patro, retired judge of Orissa High Court, be appointed, because by this order, the entire dispute has been referred to arbitration thereafter. So the question of jurisdiction at this stage comes to an end without being decided, because from that juncture, the issue has gone to the arbitration and there has been no section 9. Because my lord would kindly appreciate the situation that in December 2013, by the time Swastik Gas has come in, Justice Banerjee has already expressed his mind and said that the parties respondent will be at the liberty to take the maintainability point, though this court has entertained this thing. Just thereafter, the parties has referred this issue to arbitration. So there was no further occasion. And by this order, it has been decided and the parties has referred this to.
All right.
That's
I may just take a moment to correct my learned friend with that convenience compilation, Lord.
Yes.
Lord, after that order, there was another section 9 during the arbitration proceedings, page 22.
A bunch of orders.
In that, Lord, compilation I handed over today, Lord.
There's a bunch of orders.
My learned friend showed your lordship the order of 14th of March 2016, by which Justice Pasayat was appointed.
Which page of that bunch?
Lord, if your lordship please takes page 20, page 22. This is again during pendency of the arbitration, after they have not taken the point of territorial jurisdiction at the final hearing. The order which I had shown your lordship, that they allowed the application to be disposed of without taking the point of jurisdiction, is 20th March 2014 at page 18. Parties agree that no further order needs to be passed, etc. Then, Lord, if your lordship please takes page 20, Justice Pasayat is appointed by this court. This was not a section 11 application. This was in a section 9 application. And page 22, further interim orders of injunction were passed in section 9 on 14th March 2016, also during pendency of the arbitration. Page 22.
That's all.
Just my lord, since my learned senior friend has shown these 2 pages, would kindly consider page 26 and 27. Page 27, second paragraph. This is an order wherein Justice Boshak, while entertaining this section 9 application, has also recorded in the page 27, second paragraph, learned advocate appearing for the respondents without prejudice to his contention with regard to the jurisdiction. So,
submission without prejudice.
So we have all along kept this point agitating, but however, my lord, I still submit that 2010 no appeal, but in 2013 Justice Banerjee has reviewed his own decision.
Judgment hearing is concluded. Judgment is reserved.
Lest we say anything further.
I'm so grateful, my lord.
Lord, the order of injunction, Lord, which I showed.
Yes, yes. এই কোথায় দেখালো যেহেতু তুই ফাইল থেকে দেখি অর্ডারটা ওই 4th November 2024
কিছু নেই
আমি দাগ মেরে রেখেছি
এই তো আছে
we have it next देखो the order of injunction that was passed by a coordinate bench on November 4, 2024 shall stand reinstated and continue till the disposal of this appeal. হ্যাঁ আমার কাছে তো
শেষ হবে
What is the year of your enrollment?
My lord, 2009 January.
9 January.
Passed in 2008.
You went to whose chamber? Did you attend anybody's chamber?
Initially, I was the chamber junior of Justice Saraf.
Acha.
Great.
Non-commercial matter item number 18.
Lordship, I appear on behalf of respondent number 13 and 14. I am seeking for not this week on ground of my senior counsels appearing the matter. Both of them are indisposed today. Also, my advocate on record, Ms. Rituparna Chatterjee, is suffering from high temperature and fever.
I am ready, my lord, whatever lordship.
All three of them indisposed, he's saying. So not this week, you said?
Yes, lordship.
Learned advocate for the respondent. Respondents.
Respondent number 13 and 14.
Respondent numbers 13 and 14.
They are the main contesting.
Says that learned arguing counsel as well as the advocate on record are indisposed. Stop. He seeks accommodation for the week. Paragraph, Mr. Chaudhuri, learned senior counsel representing the appellant in his usual fairness does not object. Paragraph, list this matter once again on June 16.
Item number 19.
Lord, I appear for the response.
My lord, I am led by Mr. Charan Gupta. He's on legs, my lord. I am praying if your lordship.
Whose legs?
6:52. Charan Gupta is on legs.
Yes.
And my lord, kindly keep it on Friday, this coming Friday.
Lord, when I am not here, they obtain ex parte orders, making false representations. And now, when I am here, they will not appear.
No, my lord, it's accidentally, my lord. He was all the time he was over here, but suddenly his matter has been called on.
Lord, I'll show it to your lordship that wrong representation has been made.
Mr. Kaur will keep it fairly at the top on Friday amongst the first three items. Accommodation is sought for on behalf of the appellant. Stop. Mr. Paragraph. Mr. Kaur, learned senior counsel representing the respondents says that orders have been obtained ex parte by making wrong representation before the court. Stop. Paragraph. List this matter amongst the first 3 items under the heading Appeal from Orders on Purshu ki tarikh 13. But it will be Friday the 13th. Is that all right? Please explain what he may not know.
I'm grateful to you, Lordship.
Grateful, Your Lordship.
Item number 20.
Yes, my lord. Here, my lord, this is the matter where there was a mean profit calculation and we were supposed to come back with an agreement because we were agreeing on a certain amount per square feet that shall be paid.
Have you agreed?
The-
Last occasion, Lordship would recall, Mr. Jishnu Chaudhary was leading her. Rate, my lord, ultimately he agreed to 40, he said 46. He came down to 46. We agreed to 46. We gave our calculation.
You are the judgment debtor.
My lord, yes, I am the defendant who has. So, my lord, over here, my lord, they have preferred an appeal because, my lord, we had challenged the special referee's report and, my lord, our grounds of challenge was upheld and it was remanded. Against that, they have come up. So, my lord, while lordships were hearing the appeal, it fell whether, because the difference was not much, whether we can arrive at some sort of a consensus. Then ultimately, my lord, 46 rupees per square feet, that
Your client
I have
agrees?
been able to make my client agree.
Is that acceptable to
That
you?
has
That is acceptable.
that is
It's
acceptable.
The lowest portion which where
Oh.
The thing is, my lord, so far as the payment structure is concerned, we had handed over a list. My lord, we had said that as on from date, whatever balance we pay.
Mr. Chaudhary, both Mr. Chaudharys, either you agree or you don't agree. If you agree, put it down in black and white, come back with terms of settlement. No.
We don't agree.
Doesn't agree.
Very well. Then, my lord, kindly take it.
I completely appreciate, my lord, your lordship not wanting to hear what's happened in the settlement.
How will it be relevant?
Yes.
Excepting prejudicing us against one of you.
No. That wouldn't. Yeah,
You wish to proceed today or yes?
I can start.
No. You can start meaning what? Don't then you complete. Start and complete.
Yes, 15 minutes, my lord. This is not a matter which should take more than that. My lord, I'll start with the my lord, premise.
You obtained an eviction decree.
I obtained an eviction decree. They went before the division bench. By the eviction decree, learned commissioner was appointed to determine mean profit. Lord appeal before the division bench. Lord dismissed. They went to Supreme Court, dismissed. After admission, after affidavits, dismissed. Learned commissioner, my lord, for around a year and a half, and rightly so, my lord, had not proceeded with the reference because of the fact that the matter, my lord, was before the Supreme Court. So, my lord, that takes us to somewhere, my lord, in 2018.
January 27.
Yes, 2017, January, my lord. Then it restarted, my lord. COVID came in within 2 years. Though I do remember during, my lord, when it was slightly better, we would go to the learned referee.
Who was the referee?
Mr. Shamrat Sen.
That's it.
So, and then there was a judgment, my lord.
Good refreshments.
Yes. We, my lord, requested him, and naturally there were refreshments. So, my lord, it's part of the process. Sometimes clients don't understand, but very detailed adjudication does take a little bit of time. my lord, we don't grudge that at all. While clients may feel that if the decree takes 3 years, why should the reference take 5 years? But I say, my lord, that it was totally justified because number one, there was COVID in between and we were not functioning normally. And number two, it was a very detailed adjudication. Now, my lord, I had prayed for, this is a property which was being used for commercial purposes. So, my lord, it's a house with adjoining sheds, etc. at Hastings, 5 Commissariat Road. It was being used for commercial purposes. So, my lord, my lord, gave evidence of rupees 100 per square feet per month. I was ultimately given rupees 51.5. My evidence was entirely rejected. My expert, my lord, was not, my lord, believed. My evidence was rejected. My learned friend's expert had, my lord, given a rate of around 43 odd. And on the basis of his evidence, on the basis of his documents, Lord, it ultimately came to 50 point something, 51. My client, my lord, is in possession because they had surrendered possession after losing in Lord Supreme Court. My client didn't want to continue the litigation. So we had said that 50, my lord, is something we can challenge because we had given evidence for 100. My client said, no, I want it to be over. We thought it would be over there and then. It was a out and out win. We completely lost. But my lord, they challenged the report. I applied for confirmation. They challenged the report. And in that challenge, my lord, they succeeded to have the report set aside and my lord, be sent back for a de novo consideration.
By the commissioner.
By the commissioner. So, my lord, this is, my lord, a suit which was filed in 2014. I succeeded by January 17 in Supreme Court in getting eviction. My lord, it's for a 3-year period. My lord, 24th September 14 to 24th April 17. This is the period for which, my lord, the rate has to be determined. From 17 to 25, it's pending, and it's now to go back. We, my lord, don't want it to go back. In fact, my lord, I'll just digress. I, my lord, accepted. We had agreed, my lord, to the rate. We had agreed to the interest. We had agreed to the installments also. My client just gave one instruction. Let it end. I think we did the maths, my lord. We are giving up around 30 or 40 lakhs. But we said, very well. But I want this little bit of security. To give me some security. Either give me post-dated checks or give me bank guarantee, undertaking, whatever. But I shouldn't have to go to court again. But that is the, my lord, catch factor, my lord. I don't want to go to court again. Now, to that, they're not agreeable. So very well, we proceed. Lord, we can't force someone to give security. This is...
So there is no disagreement on the rate of interest or anything.
I agreed to everything. They said 6%. I want security. For what? For this.
Because
This is
it's
security.
payment is an installment, we understand.
Yes.
If he is agreeable to this,
No, I spoke to my...
One second, now, 1 second. They'll be happy with PDCs.
if they are agreeable to this, they will quote a degree.
My learned friend's father and I had a conversation this morning. It was quite clear that it's not possible.
But my lord, kindly, my lord, keep it next week. I'll persuade them. My lord. Because I got the impression, I must be candid.
Yes.
That because on the last occasion when we were before your lordship, I don't think Mr. Chaudhary is correctly instructed. The issue is, my lord, their major difference is they are calculating interest, my lord, from 2014.
No, from the date when the amount will fall
Here
payable.
is, my lord, since we are agreeing over here 46, whatever, my lord, instead of paying upfront, we are taking time to pay by installment. That is why they are calculating interest right from 2014. That's making a huge difference.
No, no, তুমি
But if they are agreeable so far as this
one minute, তুমি interest দেবে না?
46 দেবে এখন থেকে যা interest
মানে from 14 to today you will not give interest.
দেবেন।
He won't give interest also.
I
I had agreed to 24 installments. I thought that was what we had agreed.
24
to.
installments.
I
not the
agreed to.
payment of install.
I agreed to his rate of 46. No, now if he says for 8 years he's not going to give me interest, Lord, I'll proceed. I leave it to your lordship. I agreed to 46 also. Lord, please, Lord, take the judgment, Lord, at page 503. It's on a very small point that, Lord, we were sent back. On a very small point, which should not have been, Lord, there at all.
Issue with methodology, which is where set aside.
Lord, page 50. Yeah, true. Page 503, my lord. Lord, kindly omit everything and come to paragraph 19 at page 519. Lord, may I place, my lord, from paragraph 5, paragraph 19. তুমি কোথায় পালিয়ে যাও বলো তো এটা বার করবো দেখো hyperlink থাকে as per the minutes of the meeting the special referee has recorded the submissions of the parties to obviate any controversy at any future stage of proceedings regarding the stands of the parties with regard to the present state of the suit premises. On the same day the special referee has visited the suit premises and recorded the same in the minutes of meeting, but has not recorded whether contention raised by the counsel for the defendant was correct or not. The special referee has recorded that it is not disputed that the building that one encounters on the right-hand side was the original building, and the buildings on the left-hand side as well as the building at the far end which connects the other two buildings are later structured. The special referee has visited the suit premises but had not recorded, this is the moot issue, but had not recorded any finding with regard to the large slum area on the eastern side of the suit premises in the minutes of the meeting as raised by the counsel for the defendant. In question number 39, the counsel for the plaintiff has specifically put the question to RW1 with regard to the slums in the vicinity, and RW1 has stated that there is slum area in the vicinity. In question number 48, RW1 has further stated, I was told that the other two structures, including the shed, were constructed by the defendant. They were not constructed by the landlord. The period of consideration in relation to determination of mean profit was from 24th September 14 to May 24, 17, but the special referee has considered valuation of the land at rupees 62 lakhs per kata on the basis of the circle rate of 2018. That is beyond the reference period. So this is not the second point. First point is special referee has gone, visited the site personally, but has not noted anything with regard to slums in the vicinity. Second point is that you have used a special referee has used a rate which is beyond the period of reference. Now, my lord, please see. The special referee in his report has come to the finding that the assertion made by RW1 that the value of the suit premises would stand depressed because of its irregular shape and the presence of slum in the close vicinity is not something impresses him. The special referee has not considered that before his visit at the site, the counsel for the defendant has raised the issue of slum area near to the suit premises, but the special referee has not taken note of the same during his visit and not considered the contention made by the counsel for the defendant about the slum area in the vicinity of the suit property. The special referee has considered the valuation for the year 2018 though the reference period was up to May 2017. Special referee has also not considered that two structures, including the shed, were constructed by the defendant. So three reasons. And on that, the whole report goes. Now, my lord, I'll deal with the three, my lord, issues separately. Number one, the third issue. Special referee has not considered that two structures, including the shed, were constructed by the defendant. Special referee could, this is what they had argued in the course of the reference.
And 76 of this report is very structured. This is report with regard to the effect of other structures.
Huh? My argument was that the decree is final. The decree directs that determination of the area has to be made. Area is as per the plaint. That's the basis of the decree. Special referee, my lord, if the learned special referee questions the decree, it's not impermissible. And that's also decided. এটাও হোল্ড করেছে এই যে সুটের করতে পারে
Yes, sorry.
So, my lord, the first point is that special referee has to decide a rate. And that's all. Special referee has been given a period, has been given a property. Property is ascribed an area in by the decree. Decree refers one to the plaint. And that's the end of the matter. Special referee is not supposed to do anything else. Now, whether the report should be confirmed or not confirmed is a separate matter. But when the report is filed, any learned special referee would not decide a rate for a particular period and the area is as per the plaint. That's the jurisdiction of the special referee.
That is what he did.
That is what he did. But the learned judge, my lord, finds an error in that. The learned judge, my lord, kindly see, my lord,
Because the learned judge is of the view that two very important factors have not been considered.
Three.
And the third is that circle rate, which was prevalent in 2018 beyond the reference period.
That's my lord, second point.
Whatever it is, that is one point.
Yes.
And two other points is that two structures have been constructed by the defendant, which has not been considered, and the slum has not been considered. So two factors have not been considered at all. And there is an error in applying circle rate of 2018 when the reference period was 2014 to 2017. This is the crux
of the judgment. My lord, paragraph 21.
What he says about the circle.
My lord, I was making submission on the third point. Regarding, my lord, the two structures, the finding is special referee has not considered that two structures, including the shed, were constructed by the defendant. My lord, this is not something the learned special referee was to decide. Decree only requires him to decide the rate in respect of a property of a particular area for a period. Not question of who's constructed, who's not constructed. Not he's argued all of this in the suit, he's got nowhere. Now, this is the first point. Second point, my lord, is rate for a particular year, and the third, my lord, is slum in the vicinity. Now, I'll not deal with slum in the vicinity first. My lord, please see the judgment. I'm sorry, my lord, the special referee's report.
73 to 119.
The report, my lord, is at page 73. Now, please come to paragraph 68
That is the circle.
of the report.
Boss, yes, sir.
Paragraph 68, page 110. Lord, I'll read, my lord. Although the circle rate is of April 2018, I feel that the same could be profitably utilized in arriving at the fair market rent of the suit premises during the subject period. This is because RW1, who's not my learned friend's valuer, his expert who's given evidence, has himself deposed, albeit in another connection, that the value of real estate property has not risen, increased much between 2014 and 2018. According to RW1, between the period 2014 and 2018, there has not been any major price escalation in the real estate market. This would be apparent from his answers to question 14, 18, and 54 of his cross-examination. Point is considered. And my lord, what the learned referee has done is, I'll show how the determination is done of, my lord, the rate. It's very detailed. It's extremely detailed. I had given, my lord, evidence, which I really didn't press at the end, of, my lord, quotations received by me from other, my lord, business houses, etc., which I did not press. What I did press was, on valuation, we looked at, my lord, various evidence, my lord, property prices in the area from web portals, etc. We brought in a valuer to give evidence. All of it, my lord, the learned the special referee did not accept. The learned special referee proceeds on, my lord, there is a valuation which was possible to be determined because of a transaction in the very same property of 2018, I believe. That was number one. And number two was, my lord, otherwise, as per his report, my lord, value was determined. And then, my lord, 4 rupees or 5 rupees, it was increased. And we proceeded on that basis. So, my lord, now to say all of this is not correct. Lord, I'll just show your lordship paragraph 67 now. Paragraph 67 at page 109. While it has been contended by the plaintiff that the market value of the property would be depressed in the presence of the defendant being in occupation thereof as a tenant, plaintiff has not indicated to me as to what should be the difference in terms of percentage that the presence of a tenant may make to a market value as assessed by the Directorate of Registration and Stamp Revenue. The plaintiff did not indicate to me the factor by which the market value would stand revised in the case of property which is occupied by a tenant. RW1, that's my learned friend's witness, has disclosed documents which would show that the Directorate of Registration and Stamp Revenue, while making the valuation of the suit premises as per the circle rate on 25th April 2018, makes no difference between an owner-occupied property and a tenant property. The department assessed the market value of 5 Commissariat Road, comprising of 17.28 kathas at rupees 10 crores something, irrespective of whether the property was an owner-occupied property or a tenanted property. The market value of rupees 10.76 crores works out to about 62.29 lakhs per katha, say about rupees 62 lakhs per katha. The plaintiff during arguments also contended that the market approach, that is the sales comparison method, is the commonest method adopted for determination of market value of a property,
and that a comparison can be made for the purpose of valuation with instances of sales of similar properties in the recent past. Availability of adequate sales data of properties which are identical or allied or similar is, however, crucial. In the instant case, one can advantageously make profitable use of the conveyance in respect of the very same period in relation to the very same property. So, my lord, what had happened was I had co-owners. They sold the property to me in 2018. After the decree, I bought from them. So, using that document, this is what they produced. The other side produced. Now, my lord, please see this. Although the circle rate is of April 20, this is the second point, my lord. Although the circle rate is of April 2018, I feel that the same could be profitably used in arriving at the fair market rent of the suit premises during the subject period. This is because RW1 has himself deposed, albeit in another connection, that the value of real estate property has not increased much between 2014 and 18. According to RW1, between the period 2014 and 18, there has not been any major price escalation in the real estate market. And in the three questions, in his valuation report, one of the scenarios depicted by RW1 is to consider the fair market value and the fair market rent of the suit premises considering the above four deeds. He has proceeded to arrive at an annual fair market rent of 74 lakhs odd and correspondingly a fair market rent of 43.43 per square feet per month in May 14. So May 14 is 43.43. That's his evidence. This is evidently on the basis of the presumption that the value of the suit premises should be taken to be 52 lakhs per kata. My lord, both of us, my lord, had produced, my lord, relied upon Parks, my lord, I believe was the name of the book, my lord, on valuation. Both of us had shown. That after that matter.
He cited this this morning, cited Park.
That I bought a new edition for doing this matter. But unfortunately, I have not cited it after that matter. And I'm sure I'll get a chance again. That very, very learning experience for me because it was COVID. Towards the end of COVID, and we had all the time in the world, and I could read substantial part of Parks, Millard, to try to fend off my learned friend, which I was not successful. Of course.
You need to know the principles of valuation considering the number of properties you own. You know that.
The one person who would have enjoyed it is Mr. Aniruddha Chatterjee. But Millard, it was a very good experience. So Millard, we both gave evidence that to ascertain rental value, look at the market value, and then use the multiplier method. I said, Millard, it should be around 10%. My learned friend Millard had if I recall correctly, a 1% or 2% difference. So, Millard, what was accepted by both sides in the course of argument is multiplier method can be used for the purpose of determination. And it's a range of, Millard, between 8 and 12%, to be fair to both sides. Now, the learned referee, Millard, uses, I was trying to get 100, the rupees 100 per square feet. The learned referee, Millard, looks at the document of 2018 in respect of the same property and, Millard, determines a valuation. The learned referee also looks at my learned friend's evidence and harmonizes everything from paragraph 69. Now, please see paragraph. I'll just read paragraph 69, my lord, once more. In his valuation report, one of the scenarios depicted by RW1 is to consider the fair market value and the fair market rent of the suit premises, considering the aforesaid four deeds. He has proceeded to arrive at an annual market rent of rupees 74 lakhs and correspondingly a fair market rent of rupees 43.43 per square feet per month in May 2014. This is his evidence. This is evidently on the basis of the presumption that the value of the suit premises should be taken to be rupees 52 lakhs per kata. RW1 says that market price of similar type of land in the locality in May 2014 can be considered to vary from rupees 45 lakhs to rupees 65 lakhs per kata, but that he has considered the market value of the suit premises to be rupees 52 lakhs per kata due to A, irregular shape, and B, location of slum in the close vicinity. So, my lord, the range is, my lord, given by him, 52 to 62. And he says that I'm using, I'm sorry, 45 to 65, and I'm choosing 52 because of, my lord, irregular shape of the plot and B, location of the slum in the vicinity. As per the deeds and specifications mentioned therein, by adopting the land and building method, the valuer has thus valued the suit property as such and such and monthly rental value of 6,21,000. The said valuation was made on 7th May 2014 by considering a return and or rental yield of 8%. So that's his, my lord, evidence. RW1 has carried out a similar exercise for determination of the fair market value and the fair rent as on the date of his report. While doing so, he has considered the value of the suit premises to be rupees 60 lakhs per kata. RW1 says that market value of similar type of land as on the date of his report can be considered to vary from 55 lakhs to 70 lakhs. But he has considered the value to be 60 lakhs due to, my lord, same irregular shape and location of slum. In this scenario, he's arrived at a fair rent of rupees 43.41 per square feet per month. While he considered the rental yield in the former case to be 8%, in the latter case, he has considered the yield to be 7%. He has also given appropriate adjustments for depreciation. Now, my lord, please see paragraph 70. The two valuers, CW1 and RW1, have both used the circle rate for determination of market value of the property. Although not much in the way of objection can be raised with regard to the manner in which RW1 has taken depreciation into account, I find some difficulty in accepting the value of the land in the suit premises to be only 52 lakhs in May 2014 and to be 60 lakhs within 3 years thereafter, despite the clear evidence of RW1 regarding the fact that between the period 2014 and 2018, there has not been any major price escalation in the real estate market. I dare say that the computation made by RW1 would reflect a more reasonable estimation of fair rent in May 2014 if one considers the value of the land in 2014 to be rupees 62 lakhs per kata. This would be well within the price range mentioned by RW1 in part 2 of his report. Again, this would not be based on mere whim or ipse dixit, but based on the valuation carried out by the Directorate of Registration and Stamp Revenue in 2018 in respect of the self-same property. In taking the conveyances into account, there is no fallacy. Rather, the requirement of the sales comparison method, also known as the market approach, is met. Generally speaking, the prerequisites are as follows. Sale must have taken place within a reasonable time, bona fide transaction. It should be sale of land acquired or land adjacent to the acquired land, and land sold and acquired should possess similar advantages. All the above conditions are satisfied. There can be no doubt that the best evidence of the value of the property is the sale value of the same property under consideration and where the plaintiff is himself a party to the transaction. The four conveyances, which are exhibits one by one by two, such and such, would in the present case the best evidence of the value of the suit premises, particularly when all the transactions had taken place in the year 2014 itself. It is common evidence of the plaintiff and the defendant through their experts that a multiplier can be used to ascertain the market rental value from the value of the property, which should be between 8 and 10%. A rental yield of 8% is an acceptable factor to be taken into consideration. Moreover, in the light of clear evidence adduced by RW1 that there was no appreciable price escalation in the real estate market during the concerned period, the land value may reasonably be taken to be rupees 62 lakhs per kata, and the fair market value and fair market rent may be recalculated on that basis employed by the method used by RW1 as on 7th May 2014. I am emboldened to do this because no material or real objection has been taken by the plaintiff during cross-examination of RW1 with regard to methodology adopted. So, my lord, that was his method was, my lord, accepted. Then, my lord, the whole method is given and it comes to, my lord, rent per unit 51,000, 51.50 approximately. Then, my lord, please see paragraph 73. RW1 has also computed fair market value and fair market rent as in May 2014, as well as the date of his report, taking into account the physical measurements carried out by him and his team. I have indicated that it is not for me to enter into any controversy regarding the measurement of the suit premises as described in the schedule to the plaint and in the master summons, in the same is binding on me. I accordingly deem it fit and proper to ignore and disregard these computations. It's actually not for the referee to decide. RW1 has carried out computation of rent, which is expected from the suit premises on the basis of rentals of commercial properties in the vicinity. This is based on details obtained by him. No admissible evidence, either primary or corroborative, has been adduced by RW1 in support of data furnished in this connection. Then 75, paragraph 75 is slum area. The assertion made by RW1 that the value of the suit premises would stand depressed because of its irregular shape and the presence of slum in the close vicinity is not something which impresses me. In his cross-examination, he clarifies mere vicinity to mean within the radius of 2 to 3 kilometers. Cross question 51. The same is a substantial distance. No clarity is provided by RW1 as to how close the purported slum is to the suit premises. Nor does RW1 provide any clarification as to how the shape of the suit premises affect the value of the suit premises. The only other question that remains is as to what effect the other structures in the suit premises would have on the fair rent if the same were taken into account. In his cross-examination, RW1 says that increase in rental value would be very small. This is not probed any further by the plaintiff, nor does the plaintiff assert in real or material terms as to what is the difference. In such circumstances, it would be reasonable to consider the fair market value of the suit premises for the period for which the present inquiry was directed to be carried out to rupees 51.5 per square foot per month. And my lord, please also see paragraph 81. This is the direction. Award of mean profit 51.50, the entirety of the period under consideration. And interest on mean profit at 6% until realization. So, my lord, all the 3 points, my lord, your lordship has seen I only request your lordship, my lord, to please come to page 408 now. And in fact, I'll that I want to show, my lord. First, my lord, question. '89 onwards. The main gate on page 401, my lord, question 89 in cross-examination of RW1. Huh. 39. No, in fact, my lord, may I show two further questions? My lord, page 394, if I may request your lordship. I'll show it from the beginning. My lord, question 39, 50, 51. 39 at page 394. Are there any slums in the vicinity?
This is RW1.
One, my learned friend's witness. Are there any slums in the vicinity of the suit premises? Answer is, I have objection to the word only, but there are slums in the vicinity. Then, my lord, please see question 50. Is it your evidence that there are no modern buildings in the vicinity of the suit premises and there are only slums? Yes, if near vicinity is taken into consideration, the question is, what is the definition of vicinity? Then, Lord 51, why do not you tell the special referee what according to you is near vicinity? By near vicinity, I mean within the radius of 2 to 3 kilometers. If half kilometer is taken into consideration, there may be new building. There is also, my lord, evidence that a lot of, my lord, army buildings, new, my lord, property called Purti Bail, all right next to it. And then, my lord, question 54 is also relevant for another purpose. In the last 3-4 years, has there not been any major price escalation in the real estate market? Answer is, my valuation of the property matches with the valuation of the property in the 2014 deed, as well as government valuation mentioned in the deed. Between the period 2014 and 2018, there has not been any major price escalation in the real estate market. So this argument, my lord, which the defendant makes today, that you're taking a 2018 document into consideration, which is after the period which ends in 2017. Period is 14 to 17. You're taking in an 18 valuation. My learned friend says that this is not incorrect because this is after the period. So my answer to that is, yes, it was evidence and a length of time has been taken, and your witness has said that there is no price escalation, and it's approximate period of time. It's not 10 years, it's only 3 years. And we are looking at a document of 18, period ends in 17, starts in 14. And your witness says, who's an expert witness, he's brought by you, he says there's no major price escalation in the market. And the learned judge proceeds on that. Now, this is, my lord, the second point. Now, my lord, few other questions. My lord, please look at 89 next. মাঝখানে কিছু আছে তোমার? Milord, PC 89, Milord. That this answer which he said that there are only slums, that's Milord not correct. And from his own evidence, I'll show that. Question 1889. Is it not the main gate on Commissariat Road? Yes, it is so. On Commissariat Road, there are various army buildings. For example, residence of the Brigadier Army Club, Ordnance Club. They are not in this area, they're little ahead. About 50 meters, no more than that. How much more? About 200 meters.
14 and 18 also regarding this repeats that there's no major difference.
কোনটা?
But then 14
দেখাও। Milord, then 93. Across the road, there are huge army buildings. After the subject road crossing, these army buildings are beyond the road crossing. Milord, it's very clear that there are, Milord, plenty of Milord, army buildings and other establishments in the vicinity. And he says vicinity is 2 to 3 kilometers. And he says slums are also within the vicinity. So it's not next door. Milord, question 96 also. Milord, 94. Did you have a look at, did you also have the occasion to look at a building called Purti Bale, which is on Leonard Road? Yes. That is right next to the property. No, next to the property is a building, after which is a land, and after the land is Purti Bale. So there are 2 buildings away. My 2 plots away. Then 96, all around the building, there are swanky buildings apart from busties. Would you agree with me? To the right of the building, there's a slum area. Army buildings are on the left-hand side, across after the crossing. Please also now, Milord, come to page 408. Question 115. Would you now admit that in the near vicinity of the subject property, there are no slums but premium buildings? Answer. The criteria for valuation is the situation that was prevalent on the date of the valuation. On the date of valuation, there were slums. Accordingly, the situation is relevant insofar as my valuation is concerned. Any developments thereafter were not required to be taken into consideration for my valuation. So, Milord, he gets out that way. Now, Milord, if your Lordship comes back to the impugned order, Milord, those 3 points. One was, Milord, the learned special referee, while Milord visiting, did not, Milord, take note of any slum. During his visit, he should have taken note of a slum. Milord, under the Civil Procedure Code, Milord, learned judge may, Milord, even visit the concerned premises. But that is not for the purpose of obtaining evidence. It's for the purpose of the learned judge's understanding of the evidence on record. So that's, I think, Order 20, Rule 18. That's basic. CBC তে দাও তো আমি পার্লাবিতে রেখে এসেছি। That's not a তুমি বলবে তখন। তুমি বলবে বলে he has a Mr. Chaudhary usually has a problem with most things I do.
I have no problem whatsoever. I appreciate
You know,
all his arguments.
the kind of trouble I give him, you know, he's justified. Please see, it's Order 18, Rule 18. Power of court to inspect. The court may at any stage of a suit inspect any property or thing concerned or thing concerning which any question may arise, and where the court inspects any property or thing, it shall, as soon as it may be practicable, may make a memorandum of any relevant facts observed at such inspection, and such memorandum shall form a part of the records of the suit. So here, my lord, the learned referee went, learned referee walked into the property, inspected it, came back and delivered a judgment. Now the finding of the learned judge is, the special referee in his report came to a finding that the assertion made by RW1 that the value of the suit premises would stand depressed because of its irregular shape and the presence of slum in the close vicinity is not something which impresses him. The special referee has not considered that before his visit at the site, the counsel for the defendant had raised the issue of slum area to the suit premises, but the special referee has not taken note of the same during the visit. But this is,
it has been considered.
the report will not considers the argument of slum and has not considered the contention made by the counsel for the defendant about the slum area in the vicinity of the suit premise. That's also, my lord, with respect, my lord, not correct, because there is consideration. The special referee, this is, my lord, this is part 2, part 1, my lord. Now, my lord, part 2, special referee has considered the valuation for the year 2018, though the reference period was up to May 17. This is the end of part 2. Now, part 3, special referee has not considered that 2 structures, including the shed, were constructed by the defendant. Now, 3, my lord, is not even a relevant consideration for determination of mean profit. 2, my lord, is not correct because the special referee has considered the issue. And I read those paragraphs of the report. Why 2018 and 14, my lord, and 17. And part 1, my lord, has not taken note of the same. It's not for that reason. Learned, my lord, there are judgments, my lord, from, my lord, I think 11 CWN, that if you go, if learned judges go, it is for the purpose of appreciation of evidence, not for giving evidence. And in any case, the objection of slum has been considered. Special referee is held that there is no clear indication, and I have read the evidence that there is no real slum over there. There is no real case made out. Now, my lord, I'll just end. I just want your lordship to, my lord, see the non-consideration. My lord, my notes of argument is at page 562. Before the learned judge. Lord, kindly see, my lord, 562, 563. These are, my lord, records of what has happened. Then, my lord, the report is at 564. Then, my lord, D, my lord, is analysis of the report. Lord, we've given the rationale how it was calculated. Lord, paragraph 11. The RW1 has disclosed documents which show that the Directorate of Registration and Stamp, as at 25th April 18, assessed market value at 10 crores, works out to be 62 lakhs. So, my lord, this is the lower band. I'm sorry, my lord, the upper band, 62 lakhs. And that's as per his evidence. Then, my lord, where the document was, my lord, that's paragraph 1. And between 14 and 18, there's no increase, price escalation, no change, etc. We've given the questions in cross-examination also. Then, my lord, we've also, my lord, in paragraph 2 at page 565, we've paragraph 2, sales comparison method, 3, so my lord, valuation report proceeds on the presumption that the value of the suit premise should be taken as 52, and on the basis of RW1, that May 2014, 45 to 65 lakhs, but he's considered 52 lakhs, and there was no evidence for that reduction. But I've explained everything. Then two valuers, my lord, have both used. And then, my lord, please see, my lord, page 566, subparagraph 5. Again, my lord, I've referred to the questions and there should be no change. Then computation, my lord, be explained. This is his report. And then, my lord, paragraph 12, we have mentioned about the report. And, my lord, page 568, paragraph 12b. We've clearly, my lord, indicated in our notes that the adjustments for slum and vicinity were rejected for lack of evidence. And evidence of valuers RW1 in cross-examination between May 14 and 18, value of the property had not increased, nor had there been any major price escalation considered. And we've proceeded. Now, my lord, page 569, my lord, 3 arguments that there is a calculation error in the application. This is my application for confirmation. My lord, we accepted my learned friend's argument. There was indeed a calculation error. My lord, we made a calculation as per, my lord, my learned friend's suggestion and rectified our mistake. Now, 2, my lord, best evidence has been ignored. We've given a answer to his argument. And then, my lord, he had argued that the total area of the property is incorrect. To which, my lord, I argued before the referee and before the learned judge that when a decree is passed based on the plaint, you can't thereafter change the decree at this stage. So, my lord, these were my submissions. But if your lordship sees the details given in the notes of argument, none of it has been really considered by the learned judge. So these are my humble submissions. I'm praying for confirmation of the report. Paid for 100, I got 51. That's almost half. The client wants to finish the matter. My lord, I, my lord, want to finish the matter at any cost. My lord, I don't want to go back. Whatever rate is, my lord, acceptable, which your lordship finds to be proper, my lord, I pray for 51. I would have prayed for much more than 51, but since I've accepted the report and asked for its confirmation, I have to stick to 51. So, my lord, whatever your lordship finds, my lord, my best, my lord, my prayer is, my lord, that 51 be accepted, 51.5. My lord, anything but go back because we want quietness to the litigation. These are my submissions.
If you take the rest of the day, we can release your friends.
Yes. Sir, may I also have leave? I have to go somewhere. Sir, my learned friend will take plenty of munition.
No, if he finishes, completes today, you want to give a reply, he won't be here. So what will you respond to?
But I will listen to it. He says I won't have anything to reply to. That can work both ways. One is he will not say anything. Two is I'll be unable to give a reply. Such is the quality of his submission. So, second my learned friend won't finish today. Tomorrow's appellate
Day
side
after
and
tomorrow.
commercial. And day after I'll be
Mr.
back.
Chaudhary, if you want, we can keep it tomorrow because appellate side matters are far and few. I mean, what
I try to finish today. If not, I'll take a few minutes tomorrow.
we'll keep it tomorrow. Appellate side list gets exhausted. You won't be there.
I'm going to going to Bhubaneswar. I'll come back tomorrow evening.
Very well. Then Friday.
I hope to finish today. Point is very short. The Lordship will not get an impression that I only do mean profit matters. I was just thinking and sitting and thinking that it appears I am doing only mean profit matters. A coincidence. It's a sheer coincidence.
Well, even if you do only mean profit matters, we will never get the impression that you are mean-minded.
Well, there are two hypotheses on which all these determination proceeds. One is now, since already Lordship in the morning, Lordship has seen the, not hypothesis, two principles, I'm sorry. The best evidence should be considered. Now, in a nutshell, my learned friend, I join issue only on one aspect. My learned friend did not tell your Lordship factually one aspect, that the decree for eviction was passed under chapter 13A. Now, in chapter 13A, there is no trial. There is no trial. Now, before the special referee, first time trial takes place, and it's an admitted position that what has been described in the plaint, the property has undergone a change in the meantime because some constructions, and these are all admitted facts, constructions have been made by the defendant. The schedule to the suit property, which is part of the plaint, I shall show your Lordship. It is what they did was that they have taken the schedule right from the deed. So what the deed was, at 70 years back, the same schedule has been copied and pasted. But the asbestos sheds are no longer there. Or if it is 6,000 square feet of asbestos shed, what is there is only 120 square feet. This is one aspect of the matter. Here, of course, on this ground, on this count, I have lost before the learned judge so far as the finding is concerned. But I am just indicating the broad parameters. So, before the special referee, my witness, being the valuer, and incidentally, he is also the same Sharbojit Dotto whom we had the occasion to deal with in the other matter. He is now the present Sundarlal Mitra. Lordship is aware of Mr. Sundarlal Mitra, who is no more now.
I didn't know that.
Yes. But earlier, either you had him as your witness or you had the privilege of cross-examining him of Talbot and Company. Talbot and Company. Now, there are only one or two in the field of valuation. This Sharbojit Dotto is one of them. So either he is your witness or he is the other side's witness and you cross-examine. And it is become, we are all very friendly otherwise. Here, the second principle is, one thing which happened is, I'll show Mr. Dotto, the valuer, the defendant's valuer, that he had valued, one is per square feet rate, and the actual measurements on suit property, he has arrived at a value, and he has also given a per square feet rate. Two aspects. The second principle, which is well accepted, is that the best evidence possible is to be taken. Now, for the self-same property, there are 3 to 4 sale deeds by which my learned friend's client purchased the undivided shares of the other co-owners. 1/4, and one is perhaps 1/6 and all that. There. In 2014, period of reference is September 2014 to April 2017. 24th September 2014 till 24th April 2017.
Yes.
1/4 share, because the circle rates are now Lordship knows it is no longer dependent upon how the parties value the suit property. So you do undervaluation, you don't do undervaluation, circle rates are fixed. And if your valuation is less than the circle rate, then in case of a sale transaction, both the transferor, transferee, or seller and buyer, if it is undervalued, the difference in value will be treated as a deemed income, both in the hands of the seller and the buyer, and you are liable to pay tax on that. That is the legal aspect. So circle rates being independent, it doesn't really matter whether you are selling it to your co-owner or whether it is encumbered, not encumbered, it is independent. Now, 1/4 share was sold. The property, 1/4 share of that property in 2014 was valued at 2,25 lakhs. And straight away I give your Lordship the page. This is the affidavit of Lordship just gives me 317, that page 317. Own volume. I'm sorry, my lord, page 324, volume 3. And this is part of the affidavit of Prashant Khandelwal, who was PW1 before the special referee. His affidavit starts at 321.
Yes.
The 321 is affidavit starts. I just show your Lordship one para, 324. Para 7. There are exhibits 1 by 1, 1 by 2, 1 by 3, and 1 by 4 are 4 deeds of conveyance in the following particulars. Then deed reference, Ravi Khandelwal, name of purchaser is Dilip Kumar Khandelwal, 1/4 undivided interest, 2,25 is the valuation. And circle rates are actually much higher than market rates. So even if we take 2,25,
circle rates are higher than market rates.
Usually you match the circle rate, otherwise you are that. Now, my lord, circle rates are on the higher side. But be that as it may, if Lordship takes 2,25 being the circle rate for 25%, then my lord, 100% is 9 crores. Sale value. 9 crores. So, and this position was established before the special referee. The valuer, Mr. Dotto, also proceeded on the premise that the land value was 8 crores and odd, and building and everything. In fact, he proceeded on the premise that the property was valued at 9 crores and odd. I'll come to that. Special referee utterly disbelieved the entire valuation report of the plaintiffs. Lock, stock, barrel, everything has been disregarded. So all that Purti, Beli and all that which my learned friend submitted, my lord, it is of no consequence, because even by the special referee's report, which he is now saying that I am accepting, my lord, the special referee has disregarded his entire evidence. One line I shall show, it is clear. The learned special referee has accepted the entire basis of calculation given by the defendant surveyor. Now, my lord, lordship will just keep 2 pages side by side. Kindly take page 459 at volume 4, side by side with page 114 at volume 1. হ্যাঁ বলছি 459 at volume 4 and 114 at volume 1. One one four. The reason why I am doing this exercise is just to show that the scope of challenge of the special referee's report was very limited. And the first court has accepted the limited scope of challenge because even in this, my lord, it is changing the fundamentals of the calculation. Now, my lord, page 459, if lordship sees, my lord, what essentially, my lord, the valuer has done is, valuer has taken what would be the market value of the property and has, my lord, adopted, my lord, what we call a rental yield, which both the valuers had accepted, even their valuer has accepted. It will range from 8% to 9%. That is, if I purchase a property for ₹100, I will get 8 rupees annually rent from that at least. This is called the yield method. That is, when you don't have comparable other thing, this is one of the methods adopted. And both valuers were ad idem that 8, maximum 9 is a reasonable parameter. The learned special referee accepts all the parameters which were laid down by the defendant's valuer, which is at page 459. And, my lord, perhaps, my lord, because this has become a common phenomenon now, that the plaintiff inflates its claim as far as possible and the defendant makes his claim as low as possible, and the learned special referee tries to arrive at a mean somewhere. So the larger you inflate or the lower you make, perhaps you can, that is what people think. My lord, abandoning, my lord, all principles of valuation. Now, it is exactly, my lord, this is by way of submission I am saying, because, my lord, all our contentions were accepted by the learned special referee. My learned friend is absolutely right that everything of the defendant's valuer was accepted, save and except one. And that makes the difference. Kindly similar the first entry. Page 459. Land 17.28 kata, 52 lakh. This should be per unit is 52 lakhs per kata. Replacement cost 8 crore 98 lakhs. And Millard, the valuation comes to 9 crore 31. So, my lord, even the defendant's valuer, when he is valuing the property at 9 crore 31 rupees, the valuation is more than the admitted circle rate also. And that is why my learned friend read out that portion in cross-examination when he was said that he said that no, my valuation cannot be incorrect because it is matching even the circle rate. So, plaintiff is buying the property at a valuation of 9 crore, defendant's valuer has valued it at 9 crore 31 lakh 64,000, applied a yield of 8%. So, if somebody is paying 9 crore 31 rupees, 8% of that comes to annual fair market rent will come to 74 lakhs and odd. Monthly fair rent comes to 6 lakh 21. This is, my lord, on the item lordship will find as per the schedule of the plaint. That is, you are taking the land, you are taking, because at that point of time, my lord, when my clients had come into the property, there was construction only on the ground floor, which had a pakka construction. On the remaining portion, there was 6,000 square feet of asbestos shed, and my lord, and there were two other, my lord, another portion, 3,500 and 300. We are proceeding on that as of now, because I am now addressing your lordship on the per square feet rate. So, my lord, if the learned special referee, after accepting the entire basis of this valuation, which has been extrapolated at page 114, all entries are identical. Lordship can take it from me. 17 lakh 10,000, the second item, 5 lakh 40,000, 9 lakh 80,000, 78,000. The total is varying. The total is becoming 11 crores market value because of one singular entry which has been put in by the learned special referee of 10 crore 71. And how does he get that? He gets it from a circle rate of 2018, which is not even the period. He gets it from the circle rate of 2018, which is beyond the consideration period. And why does he rely on the circle rate of 2018? He says that my valuer has admitted that there has not been much escalation. But my valuer has not said that it is identical. In fact, he has said that land rates have risen by 20%. Well, I show your lordship that evidence. That was not placed. Will you kindly see? And this is the crux of the matter, because, well, it's changing the entire fundamentals. Well, at page 395, if lordship is pleased to come, in volume 3, I show. The Lordships have that 395, page 395, volume 3. Well, kindly see question 54. I'll just place one question from the evidence. In the last 3-4 years, there has not been any major price escalation in the real estate market. My valuation of the property matches with the valuation of the property mentioned in the 2014 deed, as well as government valuation mentioned in the deed. Between the period of 2014 and 2018, there has not been any major price escalation. Well, the learned special referee takes only this portion, but ignores the rest in real estate market. Then, my lord, comes the important part, which is not read. However, in my valuation or as per my, the land value has increased by 20%.
Increase between what period?
14 and 18. 2018, land value. And here, my lord, page 114, Lordship will see, my lord, land has been valued at 10 crore 71. Now, if land is valued at 10 crore 71 for 2014, on the basis that there has been no increase, the property valuation is coming to 11 crore 4 lakhs. Which is completely contrary to the best possible evidence. Your own deed is showing 9 crore, that's the maximum.
11 crore, where you get? High 11 crore.
11 crore. So it's making a fundamental difference in the valuation. The best evidence available, your own deed, you are buying the property in 2014 at 2 crore 25 for 1/4 share, which is 9 crores maximum. Those smaller shares, my lord, the valuation is slightly high, but I am giving the benefit of doubt. So 9 crore is the valuation, that's the maximum. You can't, it's a maximum. 9 crore is the circle rate. That's what you get it. And this is entirely on the basis of surmise. Because even this question which has been referred to, where he says that there has not been much increase, he says that the land value has gone up. So this is the only tweaking the learned special referee does, because, my lord, we gave evidence, and, my lord, the valuer was, my lord, he absolutely spot on so far as, my lord, the fundamentals are concerned, and these could not be demolished. So, my lord, these are all accepted. So I am not troubling your lordship. But somewhere that, all right, I'll accept the entirety of the defendant. Let me try to increase it slightly more. This is where, my lord, the mistake has happened, in my respectful submission. Otherwise, my lord, my client has won lock, stock and barrel before the valuer. He has accepted all our contentions. And that is why, my lord, I compared page 114 with that page to show that if lordship keeps these two charts side by side, it's an extrapolation of this chart, save and except the first row. So the land value, which was 8 crores and odd, that goes up to nearly 11 crores, 10 crores, 80 lakhs, 90 lakhs and odd. And this is where, in the sale price of the property, you make a difference of 2 crores and you say, I do it on the basis of my valuer's evidence, which is to the contrary. It fundamentally vitiates the entire valuation. I can understand my learned friend saying that, all right, I accept this 43. That is why I said you take 43 rupees. You accept that. This is the fundamental, because otherwise the special referee has accepted all other things. Only that your valuer has said there was not much difference, so I will take 2018 figures and extrapolate it to 2014. That, with respect, my lord, cannot be a principle of valuation. That is a fundamental mistake which has been done. Because now the property valuation shoots up to 11 crores and odd. Then you are applying a rental yield of 8% on that. And then you are making the calculations shooting. So, my lord, on pen and paper, it may appear that no, they are just being, it is 43 and 51. What difference does it make? A difference will come in crores. That is why, my lord, we are going into this calculation. But when two principles are accepted, if the best possible evidence is on record, which, my lord, the special referee also has recognized that the best possible evidence are those deeds. Now, if the best possible evidence are those 4 deeds, why do you not accept the valuation of 9 crores? Why do you try to increase that? And this does not have any basis. Why do you take the 2018 circle rate as a rate of 2014? So this was the primary point of attack. Number 1. Lord, if I can just show your lordship, my lord, just the points, lordship will find, my lord, our application at page 442, volume 4. But I'll just trouble your lordship with one paragraph. This is, this will also summarize whatever I have submitted right up to now.
Once again, this is your application
My
challenging the report.
The report was challenged to a very limited extent.
Yes.
At page 444, paragraph 5, lordship has found that. Paragraph 5. The defendant petitioner challenges the report of the learned special referee in the factual background as above on the limited grounds as follows. Learned special referee has taken judicial notice of the best evidence possible, namely 4 deeds of gift of the suit property itself in May 2014. Reference of the said deeds are at paragraph 65 of the said report, and has also noted that the market value forming the subject matter of deed was 2 crore 25 lakhs as on 2nd May 2014, which was an undivided 1/4 share in the self-same suit property, whose schedule was identical to the schedule to the deed in question. In view of the admitted position as above, the best possible evidence of the market value of the suit property was 9 crore as on 2nd May 2014, and the conclusion of the learned special referee of 11 crore 4 lakhs as arrived in para 72 is completely erroneous, perverse, and contrary to the evidence on record. The best evidence is that, my lord, I'll cite the same judgment here, formality. This is now, the basis of taking such market value at 62 lakh per kata is admittedly the circle rate as on 25th April 2018. Well, this circle rate is beyond the consideration period, as would be evident from paragraph 67 of the said report. On the face of record, the learned special referee has erred in considering the circle rate of 2018 when the period of reference itself is during the years 2014 to 2017, and finding to such extent is not only erroneous but completely perverse on the face of the record itself. This is the second ground. Then, my lord, see, while the learned special referee has accepted the finding of RW1, that is, my lord, my valuer, Sarbojit Dotto, that there has not been any appreciable escalation during the concerned period, the learned special referee has erred in considering the market value of 2018 and extrapolated the same for the period of 4 years thereto, particularly when the evidence of market value of the self-same property was available before the special referee for 2014 itself, namely for an amount of 9 crore. I disregard the best evidence and I use a hypothesis to inflate it from 9 crore to 11 crores. Moreover, the circle rate of 10 crore 76 as on 25th April was not of the suit property but of a vacant piece of land with identical land area on the said road, and was relied upon by RW1 to show there would not be any appreciable difference, even if the highest circle rate is taken for a vacant plot of land. Well, this circle rate was relied on by my witness because, my lord, a contention was raised that 9 crore will not show the circle rate because it is with tenant, without tenant. If you put in different parameters in the computer, the circle rates that come out, it varies. So, my lord, what our valuer did, what he did was he put in the same parameters for a dummy property in my lord, on the same road with the same area, one with tenant and one without tenant, and he took out 2 valuations as on 2018 when we were, my lord, before the just little period prior to being before the special referee, just to show that look, there is not much difference. If this is 100 rupees, this is 101 rupee or 100 rupee 50 paisa, no difference. Now that has been relied upon in saying that you have said there is not much difference. So 2018 is being extrapolated to 2014 and 9 crore is becoming 11 crores because of that extrapolation. And from that because all the parameters are same, but it's making a huge difference. The entire basis of the valuation is getting changed. Subpara E at page 445. The learned special referee, while accepting part of the evidence of RW1, has erred in not taking into account RW1 has proceeded on the best possible evidence and has factored in all parameters in his report as part of his evidence. Then annexure also. The learned special referee also failed to appreciate that there was considerable difference in the valuation by reason of difference in area as per deed and as per physical measurement, and has erred in not taking into account the actual measurement. Well, this was one of the contention. My learned friend submitted, you cannot raise it now, we go by the plain, suit is over, it has been decreed. But one question I am raising, if it is a chapter 13A decree, where will this issue be decided? Because, my lord, the learned, even the valuer has given a report, my lord, as per schedule in the...
And the problem is that special referee.
My lord, to that extent, even the learned judge has not upheld this contention of mine. I'll show that.
The learned judge passing the impugned order. How long will it take, Mr. Chair?
Another 15 minutes.
When?
Tomorrow, Lordship wants I
Tomorrow your friend is not here, so let us
Day
not
after
keep.
tomorrow. Day after
Day after tomorrow. Consider, madam, what you want to do. Because your senior repeatedly told us, do whatever you like. We don't want to go back to court or the special referee. But prima facie, we think he has been able to point out certain lacunae.
Yes.
Mr. Chaudhuri, learned senior counsel representing the appellant, completes his opening submission, paragraph. Mr. Jishnu Chaudhuri Lakota. Next, Mr. Shobhashachi Chaudhuri, learned senior counsel representing the respondent, begins his submission but does not conclude. Paragraph as requested, let this matter be listed again. Porshu diner tarik diye dao. As the number 3 item, আগে দুটো চলে গেছে তো শোনো এটাকে number 2 করে দাও এটা তো চলছে as the second item under the heading appeal from order. First item টা কি আছে রে বাবা? That's the first item করে দাও এটাকে first item. তোমায় কোন একটা পাঠাতে বললাম আজকে পেছন দিয়ে দেবো বললাম এটা সিএবি হলো থ্যাংক ইউ